Weekly list pass over item number 4.
Yesterday it took time.
Yes, madam.
This person 1,000.
Item 7.
At 7, I submitted the report of the.
He was handed over that report.
Yes, yes. Where is Mr. Mishra?
The problem is that once we start the hearing matter, so
Let me next week. No?
that this is a case where the public servant on duty has been murdered. Okay. So
Dakayatu it murder.
Dakaiti with murder. Because if you come to that 2022 resolution, where is that?
But one rule, what basis the co-accused was considered to be released prematurely?
Yeah,
that is to be seen.
adverse report ଆସିଲା ତାର ଆସିଲାନି ତାର ମାନେ ସେଠି ଯେତେବେଳେ ଇନକ୍ୱାରି ହେଲା ଏବେ ଜେଲରେ କଣ୍ଡକ୍ଟ ସେ ଯୋଉ ଆମର ଇନକ୍ୱାରି କରିବାକୁ ଯୋଉ ଗଲେ ଆଇଆଇସି ସିଏ ଯୋଉ ରିପୋର୍ଟଟା ସବମିଟ କଲେ ତାର ନାଁରେ ପଜିଟିଭ ଥିଲା ଆର ନେଗେଟିଭ ସେତେବେଳେ ଯେତେବେଳେ ଦି ଜଣଙ୍କର କନସିଡର so that is the reason why now if you come to 2022 resolution then that provision which was there in the earlier one, that is 2000, that if somebody is under life imprisonment for that dokaiti with murder, he is totally ineligible, right? So that has been taken care of in the subsequent one, this 2022. Yes. So it only says that every case can be considered. That is after 25 years. Where is that provision?
That is my page 28. I have my count on my lord.
No, you have given that particular 2022.
Yes, given that is in counter my counter annexure E by 3, page 28.
Right. Yeah,
provided that the category of the life conviction.
Page
28, my lord. Page 28.
45. 45 is the start age.
Provided that. Then internal page, my lord, 5.
Internal page 5. Okay. 4. 5. Yes.
Provided that the category of the life convicts mentioned in clause A to E may be placed for consideration for premature release after top term.
Okay. A to E means what?
A to E, my lord, come to my lord, previous page, my lord.
Okay, that is dokaiti with murder.
Dokaiti means A.
Okay.
Last line murder of public.
Murder, smuggling operation, murder. Okay. So it is not only a dokaiti with murder, but murder of a public servant on duty. Okay. But they say that provided that the categories of life convicts mentioned in so and so may be considered for consider. Okay. No. ସେଇଟା ପାଇଁ considering is 4 Positive mature relief. Having regard to the provision so and so, then policy conviction or sentence other than to mention it other than. Other than what is the also. So, except clauses A to E, the other cases can be considered on completion of 20 years. So far as this A to E are concerned, those are more serious offenses, heinous offenses. That is how the it is mentioned that it is to be considered after 25 years. Okay. Is there any other criteria that that can be also relaxed in other cases? এইটা তো তাদের এইটা আমার যে চারটি কোশ্চেন অফ ভয়েস যদি সাবসিকুয়েন্টলি ডিভাইড দ্যাট ইজ মোর বেনিফিশিয়াল যেটা বেনিফিশিয়াল হবে সেটা ওটা in between 22 রিলিজ হয়েছি 2022 না তারপরে সেটা that man who was released, that was prior to 2022.
No, that is prior to that is
When there is a total bar in terms
at that time it was not
there was 2000 there is total bar.
That was to 2010. He released in 2019. At that time 2010 was there.
2010. That was more
liberal. Here it is 25, that is 20.
Or 20. Say 2010 no এটা টিকে দেখে সেটা annex করে জানি. So if you mention it just like this, rate of conviction is. So what you mean to say, Mr. That's 2000 total restriction for such offense. Then you say that that was liberalized in 2010.
10.
Page 33. 33 Bhartam. Resolution dated 5/5/2010. And extra D by 3. এটা তো 2010 এদের দেখে নে কোন কোশ্চেন should not exceed 25 years. Other mentioned other problems A, B, C. Number 3. Eligibility for premature release. The following category of inmates shall be eligible to be considered for premature release by the state sentence board. Okay. Every convicted prisoner, whether male or female, undergoing sentence of life imprisonment and covered by so-and-so shall be eligible so-and-so after serving out sentence of 14 years of actual imprisonment without any remission. It is therefore clarified that completion of 14 years in imprisonment by itself would not entitle a convict to automatic release from the prison, and state sentence review boards shall have the discretion to release a convict at an appropriate time in all cases, considering the circumstances in which the crime was committed and other relevant factors. Whether the convict has lost his potential in committing the crime. Okay, then possibility of reclaiming the convict as a usual member, socio-economic condition of the convict's family. 433A was enacted to deny premature release before completing 14 years of actual incarceration to such convicts as stand convicted of a capital offense.
Mala, kindly come to page.
Yes, Mala. ଏଇଠି ଗୋଟେ ଯୋଉ ଲାଇନଟା କୁହାଗଲା ଯେ certain categories of convicted prisoners undergoing life sentence would be entitled to be considered for premature release only after undergoing 20 years,
20 years,
including 8
including
as
the
you say,
remission.
certain categories.
Next page, my lord. That A, kindly come to the next page, my lord. Now we are in A, regarding the murder with the public service.
Yes. ये लाइन बंका कला के can see the progress of the modification of the change. The principal conclusion not fully with the modification for that. Quality of the service. On 20 years. সেটা কোন সেই যে 20 years টা কোন
সেটা এপড় নেক্সট পেজ রে
ABC
ABC
murder with docket.
এটা হলা না প্রেজেন্ট যেটা আছে ABC মার্ডার উইথ ডকায়েটি এন্ড
এইটা
এটা পেজ 16 মানে
তারপরে
তারপরে আছে এগুলা সেটি তଳେ
সার্ভেন্ট অন এইটা তো
এর আছে দুইটা
ABC আছে এর দুইটা আছে
ডকায়েতি with murder and public servant.
হ্যাঁ
So that means that the total prohibition which was there in 2000, that was little bit relaxed
in 2010
guidelines, and but it was mentioned that 20 years if somebody undergoes the actual imprisonment, then his case can be considered, right? On that basis, both the persons matter were taken up, right? This man who was granted premature release, so also this present appellant.
my lord.
Now, then what happened?
they have done a mistake filing this challenging the last occasion. They have not challenged the prior.
That was the reason that that we pointed out then other day.
Last occasion my lord was.
আচ্ছা সেই যোটা ଆପଣଙ୍କର রিলিজ ହେଲା ଆର ରିଜେକ୍ଟ ହେଲା ସେ what is that order?
Yes.
Co-convict. His appeal was also dismissed, right?
Yes, sir.
Co-convict was released prematurely
My lord,
on Quebec.
annexure 3 of the writ petition, page 18, my lord. Kindly have a glance.
Annexure 3, okay.
Page 3. 21, 21st 11
21/11/2019 ପାଇଲେ
21/11/2019
ଆଚ୍ଛା ତା ଦେହରେ ଆସିଲେ ସେ ରେଲେଭେଣ୍ଟ ପେଜ ଟାକୁ ତାର ଯୋଉଟାରେ ଲେଖା ହେଇଛି ଏମାନ ଦି ଜଣଙ୍କର ନାଁ
ସେଇ page ତ
ୟାର ଆଲାବାଲା ତାର ଏଇଟା କଣ ଏଟା I am to inform that live convict Gopal Mahakur who was undergoing imprisonment also on the premature today. ଆଚ୍ଛା ତା ନାଁ ହଉଛି ଗୋପାଳ ମହାକୁଡ଼
ନାଇଁ ଗୋପାଳ ମହାକୁଡ଼
ଗୋପାଳ ମହାକୁଡ଼ ରିଲିଜ 23/11/2019 ରିଲିଜ ହବା ପାଇଁ ଅର୍ଡର ହେଇଗଲା ଆର ଯୋଉ ରିଜେକ୍ଟ ହେଲା କାହିଁ ସେଟା
ସେଇ ରିଜେକ୍ସନଟା ନାହିଁ ମୋ
ସେମାନେ ଦେଇନାହାନ୍ତି
ସେଟା ନାହିଁ ମୋ ପାଖରେ
by that time he had already completed 20 years.
Yes.
In prison.
2019 as per my custody certificate at page annexure A by 3 my lord. Now it is completed to 22 means in 19 my lord most only.
So that is today to almost more than 23 years because he was taken to custody.
Yes, just a minute. Let us come to that again. Kuda sila jura mein dekhte. No, your first one was rejected when that he was granted on that premature release from 23/11/2019. So
My lord.
your premature release was application was rejected during that period.
That, yes, that
Your
Nahi, sir.
applications also, Gopal Mahakur's application were considered together. His application was allowed. whereas your
ଆପଣ
application
ଏଇଟା
was
ଦେଇଛନ୍ତି ଆପଣଙ୍କଟା କୁଆଡେ ଗଲା ଯୋଉଟା ରିଜେକ୍ଟ ହେଇଛି?
2019 ରେ।
reject ମୁଁ letter ଟା ଦେଇଛି ଆଜ୍ଞା।
But କେବେ ହେଇଛି? We want to know the date.
ଆପଣ what you are now challenging, he is rightly pointing out, you are making a submission that when 2010 guideline came and due to such guideline, one of the co-convict has been released prematurely by the government.
My lord.
My case was not, my case was illegally turned down. My application was rejected, right?
My
So
lord.
that should have been challenged.
That has got
If that is not challenged, what you are challenging now is at present what you are challenging.
annexure 1, my lord,
Annexure 1. Let us see what is annexure 1.
and relevant page 15,
Annexure 1 is dated 2/2/2023.
23, and page 15.
Just a minute. Annexure 1, 2/2/2020. Mr. Mishra, make a point clear. You have not challenged the earlier rejection order before this court, right?
Right, my lord. 19 order I have not challenged.
Okay. Now
I am challenging annexure 1, rejection relevant
the
point
date is
serial number 9.
2023.
Yes, 9. There's one line rejection which doesn't satisfy the criteria about blood.
No. Question is that, is there any scope now that prior to 25 years your case can be considered? That provision which was there at that point of time, it was that 20 years in every case it can be considered. That has now been streamlined. That no, it is now 25 years. So as on the date. Now they are referring to the they are referring to the backwards circular. It can be those who have been talking and the substitution. No, he was considered. He was considered and his case was rejected. What is not challenging that? Problem subsequently challenging on the subsequent beyond this data. You are right that suppose he could have challenged that order. The matter is different, but now he is challenging this order, which is passed relying on 2022. So, there are 5 amendments. 5 amendments. In terms of his case was considered, he was discriminated. He have challenged. No, he was not discriminated on. He was discriminated for a particular ground because of the adverse report, which he has not challenged. So that chapter is closed. Now he cannot say that one has been released. I have been discriminated, right? Because you should have challenged that order at that point of time. So that chapter is now closed. Now when the authorities now are considering on the basis of the latest guideline. So latest guideline against
when he made an application for reconsideration of his case,
My lord, kindly.
by that time it has come. Yes, yes.
My lord, may I try your lordship? Kindly see annexure 2. That is way back 2021, relevant page 17. Kindly see. The list of cases rejected by the states. Page 17, my lord.
Yes.
If my lord, the 2022 guideline, before that, my lord, there was a
serial number
4.
4.
That was, my lord, board was held on 2/12/2021. My lord, top of the, my lord, kindly have a glance.
Yes.
If I will take the, my lord, hinges of 2021.
And this is the outcome of that.
No,
No.
That was dropped due to reason that Rule 4, Sub-Rule 4 of Rule 5 of Law Department Resolution dated 5.
Just a moment. Okay. He had spent more than 24 years. He just rejection
The DIG has
এটা তো আমি ক্যালকুলেট করে দেবো এটা যে
ଏଥିରେ ସେମାନେ ଲେଖିଛନ୍ତି 24 ବର୍ଷ ବୋଲି। wrongly they have calculated.
wrongly calculated. Wrongly calculated.
ବର୍ତ୍ତମାନ ବି ତାକୁ 23 ବର୍ଷ ସେ କହୁଛନ୍ତି କାଉନସିଲ ର ସବମିଶନ ହଉଛି
Again, ସେଟା ନୁହଁ ଯେହେତୁ custody period.
Custody certificate we have produced.
This is the wrongly they have written, but this was taken into consideration, and the rejection ground
which was taken into consideration.
Not taken into consideration. 2021, the board rejected my the case, taking into account that the last rejection as per sub-rule 4 of Rule 5.
This is dated. You are relying on Annexure A.
Annexure 2. Annexure A. Yes.
Annexure A, which is that state sentence review board that was held on 2/12/2021, right? And your number is serial number is 4. Tarkeshwar Chaudhary.
Again.
The convict has spent more than 24 years. It's an error of record.
Error that is right. Maybe that time 20.
Including remission, the convict along with so and so committed docket in UCO Bank Sector 5 Raurkela and murder of a bank person Ranjit so and so exploding bomb.
This is ground of rejection.
Right. Yes. So by that time, when this order was passed, at that point of time, which guideline was in force?
Guideline 2010.
2010. So 2010, there was a provision that after 20 years, your case can be considered. So rightly, they took up your matter, but taking into account whatever maybe they rejected it. So they have also stated that merely because you have completed 20 years, that cannot be a ipso facto a ground to release you prematurely. Other factors are to be also taken into account.
When the 2010 was rejecting his application on this ground was also incorrect. He did resume ground for rejection that the conviction for committing docket is also murder of a public servant. That is the ground
of my lord, 2023
and not he even it was taken off. That is the not see really he's challenging
and yes, 2013-1 2023 page 15. Kindly see the ground. The ground adverse report of district authorities.
Wait, they're not going to that.
Usually.
If they would have been challenged the 2019 and 2000 previous, because there are 2 to 3 times they have rejected. 21 also it was rejected.
21 rejected.
ତାକୁ ଯେତେବେଳେ ରିଲିଜ କଲେ ଆର ଇଏ ହେଲା ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କଲେନି ଏଇଟାକୁ ମଧ୍ୟ ସେ ଯୋଉଟା ଆନେକ୍ସଚର ଏ ରେ ଯୋଉଟା ହଉଛି ଏ କଥା ଟୋଟାଲି ତାଙ୍କ ରିପିଟିସନ ଆଭରମେଣ୍ଟ ବି ନେଇନାହାନ୍ତି ଯେ ଏମିତି ଗୋଟେ ରିଜେକ୍ସନ ହେଇଛି ବୋଲି.
What is that adverse report?
Yes,
adverse report
that is my submission, my lord.
That report, have you annexed this report?
That report they have not supplied because my contention, my lord, the authority has not applied the mind. If my lord, if I will go on one ground, my lord, appreciate Rule 7 of the 2020-22 guideline. If my lord, suppose for the sake of argument, it is my lord to be taken into consideration.
There is no other, Mr. Mishra, is there any other relaxation anywhere that prior to 25 years?
To take up this issue or to, yes, that is rightly your lordship is.
If there would have been any other, suppose somebody's, in spite of that, there would have been something like that, one who crosses the age of, let us say 65, or one who suffers some kind of disease, terminal diseases, let us say cancer, etc. his case can be specially considered even though he has not completed 25 years in case of dacoit with murder.
But a recent Supreme Court judgment said
That's
Lakshman.
a minute.
Yeah.
The business interests are required to be present for the state judges for due consideration only after outside of a period of 1 year. So based on last suggestion as per the answer, written act. If he will any should be well. And any other consider what shall we learn for it since this on your page was your time. That's what's the part. What shall we learn? That will be that will be what's the part of the can be considered because of the present report which were produced. Okay.
Mr. Das,
My lord.
you come to that page number 14.
Page number 14 of the list, my lord. Yes, improved communication. My lord. Annex 1, my lord. Yes. This is the last sentence of the first para. It starts the rejected cases. Last sentence of first para. First para, my lord. Yes.
The
Page 14.
rejected cases.
From the date of last rejection. Yes.
You read it once again, in inviting a reference to the subject
Noted above,
yeah.
I am directed to enclose herewith a list of the convicts under Annexure A, by Annexure A, whose premature release proposals were rejected by the State Sentence Review Board in its 42 meeting held on 13/1/2020.
Petitioner's case was also rejected on 13/1.
My lord.
On the ground as
mentioned against each, the rejected cases are required to be placed before the State Sentence Review Board for reconsideration only after the expiry of a period of 1 year from the date of last rejection as per para 8 sub 4 of the Odisha Gazette notification dated 19/4/2022. You are therefore requested to submit necessary.
So that 1 year period has already elapsed.
And the ground of rejection was adverse report of district authorities.
Now the report is good, so 1 year has passed.
Report.
Yes,
Do you have a copy of this report?
yes, my friend has. Grateful.
This writ petition in the nature of habeas corpus has been filed challenging the order dated 2/2/2023 of the Deputy Inspector General of Prisons bracket headquarters wherein the decision of the State Sentence Review Board in its 42nd meeting held on 13/1/2023 rejecting the application for premature release of the petitioner has been annexed
is under challenge. The ground of rejection is adverse report of the district authorities. It appears that have you got the trial court judgment with you?
Yeah. So it is not.
Yeah. It appears that the petitioner Nilu alias Tarkeshwar Kumar Chaudhary face trial से जो आरटा जो जाइथिला तानाडा कोन
Gopal Gowda.
along with
Gopal Mahakud.
one Gopal Kumar Mahakut and others and 3 others for them face trial in the court of London Additional Session Judge Raurkela in Sessions Trial number 118/45/2001 for offences punishable under section 302/34 of the Indian Penal Code, section 5 of the Explosive Substances Act, read with section 34 of the Indian Penal Code, section 396 of the Indian Penal Code, section 25 of the Arms Act, the London Trial Court by judgment and order dated 17/7/2004 found the petitioner, so also the other co-accused persons, guilty under section 396/34 of the Indian Penal Code, 5 of the Explosive Substances Act, read with section 34 of the Indian Penal Code, section 25 of the Arms Act, read with section 34 of the Indian Penal Code. And sentenced each of the accused persons to imprisonment for life and to pay fine of rupees 25,000 each in default to suffer RI for further period of 5 years for the offence under section 396/34 of the IPC, RI for 5 years under section 5 of the Explosive Substances Act, read with section 34 of the IPC, and RI for 3 years na କେତେ ଲେଖା ହେଇଛି ଦେଖା ଯାଉନି ଟୋଟାଲ 3 ଲେଖା ହେଇଛି appellate court judgment ଟା ଅଛି
Let court,
No.
High Court.
3 years under section 25 of the Arms Act, read with section 34 of the Indian Penal Code.
Please dismiss the number.
Huh?
Appeal dismiss is number.
The petitioner preferred criminal appeal number টা কোন
Criminal appeal Millard 248 of 2004.
Dismiss on
CRL number
Post upon 23rd of December 2011. That was already filed. Again, I am giving.
Criminal Appeal Number 248 of 2004, which was dismissed by this court as per judgment and order dated 23/12/2011. Needless to say that the criminal appeal of the co-convict,
Also,
that is
Gopal
Kumar
Maharkot.
Mahakur, was also dismissed.
That is also number.
Okay, they give in CRLA number
271.
271 of 2004, as per judgment and order dated 23/12/2011. Interim data, common judgment 81. In this writ petition, it is contended that the petitioner is languishing in special jail Raulkela for the last 23 years, since 2000. And the proposal for premature release of the petitioner was rejected by the State Sentence Review Board on 2/12/2021. On the ground that the convict has spent more than 24 years of imprisonment, including remission, and the convict, along with 4 others, committed dacoity of UCO Bank, Sector 5, Raurkela, with murder of bank peon Ranjit Soren by exploding bomb. And the proposal for premature release was once again rejected on 13/1/2023 on the ground of adverse report of the district authorities. It is further averred that the co-convict Gopal Mahakur, who stands on the same footing like the petitioner, has been granted premature release by the Directorate of Prisons and Correctional Services, Odisha, as per order dated 21/11/2019. The reliance has been placed on Rule 836 of Odisha Model Jail Manual 2020, which prescribed the guideline for premature release of live convicts. It is further stated that non-consideration of the case of the petitioner by the opposite party number 2 for premature release is contrary to law and violation of norms and guidelines as stipulated by the state government. It is further stated that the petitioner has already attained the age of 55 years and not having any adverse report in respect while in jail, and the petitioner has volunteered various activities in the jail, and he was also a part of paralegal volunteering for which his case should have been considered for premature release. It is further stated that the petitioner is well educated, is taking class since last 13 years in the jail and educating the convicts voluntarily, and some of the convicts completed high school certificate examination in the meantime. It is further stated that since the appropriate government has the authority to commute the sentence as per the provisions prescribed under section 432 and 433 of CRPC, and Article 161 of the Constitution of India empowers the authority for commuting the sentence. The rejection of the petition for premature release of the petitioner by the opposite parties is contrary to law. When the matter was taken up on 25/9/2023, and we found that the sole ground of rejection of premature release by the State Sentence Review Board, which was held on 13/1/2023. Huh?
2023.
Good.
On 13/1/2020.
31, right? 31.
The data kebe when it was considered kebe exactly data
13/1/23.
13
31.
Page 3 of the order.
এই অর্ডারটা কমপ্লিটেড হয়েছে তারপর we made a query to the Learning Council for the state as to whether there is any rule framed or any scheme of remission or any guideline issued by the government on premature release of the convict. Land Council for the state drew the attention of this court
to the guideline for premature release 2022, hereinafter 2022 guidelines, which was published in the Extraordinary Gazette of Odisha dated 19/4/2022, whereunder clause number 6, categorization of prisoners for premature release has been made, and it is stated that convicts who have been imprisoned for life, inter alia, in case of dacoity with murder, their cases for premature release will be considered after completion of 25 years of incarceration. Order to jar lekha hai jo ye onje 22 ye onje 25 years le gulu 22 ta docaity murder considered docaity murder of the public servant 25 years it of making is like we observed in that order that since, as per the averments taken in the writ petition, similarly situated co-convict Gopal Mahakud was released prematurely prior to the completion of 25 years of incarceration, we were of the view that government is not strictly following 2022 guideline while considering the case of premature release in case of live convicts mentioned under clause 6A TO2E. And counsel for the state placed the written instruction dated 21/11/2022 received from the Superintendent of Police Raurkela and pointed out that the adverse report against the petitioner indicates that the Superintendent of Police Raurkela entrusted inquiry to the Inspector in charge of RN Palli Police Station on the premature release proposal, and the inquiry report was submitted which indicated that law and order problems cannot be ruled out if the petitioner is released prematurely, and there is apprehension that the petitioner, keeping personal grudge over the informant and his family members, and that the petitioner might not lead a honest livelihood. We made a query to the Learning Council for the state as to whether the copy of the inquiry report of the inspector in charge of Arenpalli police station was supplied to the petitioner to have his say on the matter, and whether the petitioner was given any opportunity of hearing on the adverse report. Learning Council for the state took time to obtain instruction in that respect.
Hey, Regender para 6 mirror kindly that SP has to adopt 7/4. Oh, sir.
When the matter was taken up on 13/11/2023, the Learning Council for the state submitted that by filing counter affidavit that there is no provision in 2022 guideline to supply the copy of the inquiry report to the convict and to give an opportunity of hearing. for which the inquiry report of the IIC RN Police Station was not supplied to the petitioner and no opportunity of hearing was given to him. Learned counsel for the petitioner placed reliance in the case of decision of the Honorable Supreme Court in case of Hitesh alias Bapko Shivsankar Dabe versus State of Gujarat, reported in 2023 Live Law SC 72. Have you got that decision with you? Which paragraph, according to you, is relevant? Don't go to the head noting. Come to the paragraph.
Yes, yes.
No, that is with us. Please show us that paragraph. This
4.
head noting which has been made, come to the head noting first.
Yes, Lord.
In determining the entitlement of a convict for premature release, the policy of the state government on the date of conviction would have to be the determinative factor, right?
Fine.
However, if the policy which was prevalent on the date of conviction is subsequently liberalized to provide more beneficial terms, those should also be borne in mind, right? So where is that such type of observation?
Objection para 4.
Let us see. Following the law laid down by this court in determining the entitlement of so and so, the policy of the agent, the date of so and so is determinative. However, if the policy which was prevalent on the date of subsequently so and so to be borne in mind. Eta take on, wherein it is held that while determining the entitlement of a convict for premature release, the policy of the state government on the date of conviction would have to be the determinative factor. However, if the policy which was prevalent on the date of conviction is subsequently liberalized to provide more beneficial terms, those should also be borne in mind. What other decision you relied
Yes,
upon?
other decision, Miller. The principle in Rajo versus Rajua, Rajendra Mandal.
The Land Council for the petitioner also placed reliance in the case of Rajo alias Rajua alias Rajendra Mandal versus State of Bihar and others, reported in AIR 2023 Supreme Court 4084. Which paragraph?
Eta again the file kutla author the relevant how the boards to consider taking into
record.
That was record, but
it underline korchandi.
Aage mo office copy ta.
ठीक है जी, कोई ये paragraph
Principle
quote करियो ना.
Last item रे टिके करछि तळे बाकी
Last item देखियो.
नहीं पर अछि. Honorable Supreme Court remanded back for fresh.
Paragraph 1920. 21. 23. अच्छा, ये paragraph उड़ा जोड़ा ये को जल्दी quote कर देगा. Wherein it is held as follows. से 19 paragraph रो कर जल्दी 19 कोड़ी है ना? Then 23 तापरे 25
ठीक तो एतिक तो
ଆଉ ଗୋ ଦିଟା ଜଜମେଣ୍ଟ ଆଣିଛି ଆଜି my lord
ଦିଅନ୍ତୁ।
see
ଏଟା ଏଟା
the
ଲେଖି ଦେଖନ୍ତୁ ଦେଖି ଦିଅନ୍ତୁ ଆପଣ
20, 23, 25
Delhi High Court relying on Honorable Supreme Court judgment, my lord was saying the conduct and the hijack plane hijack case. This is the judgment.
the learned counsel for the petitioner
Sadhya.
further placed reliance on a single bench decision of Delhi High Court dated 2nd November 2023 passed in WPCRL number so and so. Which paragraph?
Para 10, 12, 15, 16 and 17.
10 एटा दे मार्क करना दी
सर मो हितरे करिने कोर्ट कॉपी रे मार्क करने
10,
10, 12,
10 12 then
15,
hmm,
16 and 17. Kindly see page para 12 where the judgment of Honorable Supreme Court has
16 and 17
16 तो 3 थर
16
sorry
टा 3 थर ही
thar बारी है एटा 17 हवा କଥା
कोटा
16 टा 2 थर लिखा है
आपण को थरे कोटा को रिलाय करियो चाहते सेकंड 16 ना थर्ड 16
आज्ञा सेकंड फर्स्ट दीटा को
अच्छा
जोतरे लक्ष्मण नस्कार जजमेंट को रिलाय कर
in view of the aforesaid सेटा रिलाय करियो चाहते and then the next one
in the
okay
fractions of the last
ए दीटा जाको अछि जोटा रिलाय कर एटा 16 एटा को 17 हबो हला yes next case
Miller kindly see the judgment of Honorable Supreme Court the 2000 volume 7 Supreme Court cases 6 to 6
को paragraph कोन
para 6 and 7 and 9
6 7 and 9
their lordship in Supreme Court decided that whether there is any chance of future or recurrence committing
okay
crime,
then
whether the convict has lost potential.
it's all right then next
That's much.
that's all right the learned counsel for the state filed the counter affidavit आपन मेन पैराग्राफ गुडा कहि गेले मिस्टर दास काउंटर मेन पैराग्राफ गुडा कोनथु तो para 5 मेलर where in paragraph 5 टा लिखंतु तापरे पूरा कोट कर देबे है ना तापरे
para 7
7
para 8
8
9 मेलर
9
10
10
11 12 मेलर
11 and 12 है ना the learned counsel for the petitioner filed the rejoinder affidavit to the counter affidavit filed by the opposite party तार relevant paragraph गुडा कोनथु
4
4
and 5
5
6 6 Miller para 6
wait 6
and 7
से जो ता देर जोड़ा कोट हेछि ना से जो क्लॉज गुडा का सर्कुलर गुडा से गुडा का छक्की छक्की पकई देबे है ना यस तापरे 7
so again 7
7
8
8
9 to my lord has
Nine,
already
sure,
that is yes where the SP has to apply his mind
okay
there is contravention of
जोड़ा
rule
तो
7
आपण देखिले सब
again and my lord
एडा सब डिसीजन बेस छाड़ दियंतो
आगे तापरे again 12 my lord has already observed that is not required.
डिसीजन छाड़
but that was my lord
and 14 कर दियं the natural
Grateful,
justice
obliged.
14 all right এটা পরা সেই 14 paragraph 14 না 7 টা
must have been superannuated.
अच्छा 7 टा भी कर दिया तो सी जो रीजेंडर कोई चीज और कोई चीज तो
mechanically they have to, that is
the সেটা লেখি না দিতা যে
আগে লিখি দিয়েছে আগে
the Learning Council for the I would separate paragraph for it. The Learning Council for the state submitted that since in view of the decision of the Honorable Supreme Court in case of Hitesh alias Bapko Shivsankar Dave, the policy of the government on the date of conviction would be the determinative factor in determining the entitlement of a convict for premature release. Since the petitioner was convicted by the London Trial Court on Kebe data
2004
SCU trial court
read 17/7/2004
17/7/2004 the relevant guideline which was in force at that point of time was of 2000
2000
সেটা কাহিনী সেটা দিকে
that is
I have filed money.
26 September 2000.
That is 26 September
2000
wherein 4 Miller. Phase 2. Wherein the convicts who commit murder of public servant on duty and Dokaiti were totally ineligible for premature release. However, in 2010,
blood that is annexed to the counter okay
counted D by 3 Miller.
yes D by 3 page 33 minutes.
However, as per the resolution dated 5/5/2010 of the Law Department Government of Orissa, it was observed that certain categories of convicted persons undergoing life sentence would be entitled to be considered for premature release only after undergoing 20 years, including remission. And the period of incarceration inclusive of remission, even in such cases, should not exceed 25 years. And the convicts who have been imprisoned for life of murder with Dokaiti and murder of public servant on duty were also included in the guideline to be considered for consideration of their case for premature release after undergoing imprisonment for 20 years. Subsequently, in 2022, April 2022. Subsequently, on 19th April 2022, another guideline came where it is mentioned that
Proviso. Provided page 49. 6 starts from 6.
yes, that while in other cases of life imprisonment, the premature release can be considered on completion of 20 years of imprisonment, including remission. But so far as the convicts who have been imprisoned for life in case of dacoity with murder and murder of a public servant on duty, their case will be considered on completion of 25 years of incarceration. The Learned Council submits that the appellant, the petitioner has not completed 25 years of incarceration, and therefore, as per 2022 guidelines, he is not eligible to get premature release. The last, the impugned order under challenge is dated 2/2/2023. कोर्ट लिखते थे जो हाँ. However, when the case of the petitioner was rejected on 2/12/2021 by the State Sentence Review Board, which is annexed to the writ petition as Annexure 2, it is indicated that the petitioner has spent more than 24 years of imprisonment, including remission. This is not incorrect statement because you see remission अच्छी remission गोटे प्रत्येक वर्ष गोटे period ही जाए तेणु आपण actually जेतिकी नबो सेटा को तादिरे add ही जाए. So that is how he has mentioned. They are right. So 24 years including हाँ. The
Annexure A by 3 देखो details ଅଛି.
हाँ.
running page
तेणु जणे हुए तो एक्चुअली 5 वर्ष जाइथिबो बुझिले ना प्रत्येक वर्ष तांगर रेमिशन थिबो तांगर कोन 2 मास ना केते गोटे रेमिशन आछे ए जो रब्बार फबार गुडा मिसेई किन दियंती तेणु सी तार आसी जीवो 5 वर्ष रे 10 मास तेणु तार धरा जीवो जे सेटा 5 वर्ष 10 मास
2022 रे इंक्लूडिंग रेमिशन 26 वर्ष केते.
हां. However, while in the impugned order dated 2/2/2023, wherein it is mentioned that the premature release of the convicts, the premature release proposals of the convicts, which were rejected by the State Sentence Review Board in its 42nd meeting held on 13/1/2023, on the grounds as mentioned against each, can be placed before the State Sentence Review Board for reconsideration only after expiry of a period of 1 year from the date of last rejection order, as per para 84 of the Odisha Gazette notification number 1174 dated 19/4/2022.
Not that he has not completed 25 years in terms
Ah.
of the revised
And the ground of rejection was the adverse report of
district authority.
the district authorities, and since 1 year period has already
May I-
elapsed.
May I please, my lord?
Ah.
This is the letter of 29/12/2021.
Yes.
No.
Sorry,
We are referring to Annexure 1.
Annexure
Yes.
Annexure
Just a
one.
minute. 2/23.
2/23, my lord.
Reason of rejection is adverse report of district authority.
No, that is not. The rejection is dated 13/1/23.
Yes.
First page re dekhun. On the grounds mentioned is,
My lord.
and the rejected cases are required to be placed before this one.
My lord.
So that period
My
has
lord.
already
Yes,
elapsed.
yes, my lord. Please.
And since that 1 year period has already elapsed
Right.
in the meantime,
My lord.
therefore,
Understood.
the State Sentence Review Board has to consider the case of the petitioner in accordance with law. The London Council for the State has produced a report from the Superintendent's Special Jail, Rourkela Welfare Services, dated 8/2/2024, wherein it is mentioned as follows. पूरा total quote कर दिया है ना? Edo. In view of the present conduct of the petitioner, and since he has already completed the requirement of 25 years incarceration, including remission, as per the 2022 guidelines, the State Sentence Review Board shall consider his case afresh without being influenced by the earlier rejection orders. And
Also taking into consideration the report. Also taking into consideration the report for the also taking into consideration the report given by the superintendent.
taking into consideration the report of the superintendent so as quoted above. Hala? The entire exercise should be completed within a period of 2 months from today. A copy of the order be handed over to the Land Council for the state for onward communication to the authority concerned. Accordingly, the writ petition is disposed of. Draft करिए देखेबो है ना शाम को देखेबो तापर
But I humbly express my gratitude, my lords, of patient hearing and calling for reports. My lords, wisdom, I grateful, my lords.
yes. Next.
Free copy, ma'am.
Yes, yes, obviously. ସବୁ ଦେଇଦେଲି ତ ତମକୁ ଡ୍ରାଫ୍ଟଟା କରିବ ତାକୁ ସାଇଜ କରିଦେବୁ 14 ସାଇଜ ହେଲା କରିବନି ସାରଙ୍କ ପାଖକୁ ନେବେ ତାପରେ ଦେନ୍ କମ୍ପ୍ଲେନ୍ ହେଲା
Item 9.
No, 9 is the hearing. That matter. What happened, Mr.
Mr. was sitting here. Mr.
May be lost.
challenging the judgment.
Judgment slightly further.
Challenging the judgment order of conviction and sentence passed by the London ad hoc additional session judge Bodai Miller on 26/7/2005. This present
As
appeal is
it
prepared
appears
by
from the first page of the paper book, there are three appellants.
Now,
Huh?
three appellants, one is
Just a
died.
minute. आगे कही दियंतु गोटे फर्स्ट appellant ना होची
Mongara Munda.
Mongara.
मंगरा मुंड ना मुंडा
Munda.
Munda.
एटिका मुंड लिखा है नंबर 2
Gobara Munda.
फूड लिखा है तारो ये कहीं अपील मेमो कहीं मंगरा मुंडा yes that is at page number 3 तापरे होची
And the next one is the Sunya Munda.
Gobara, just a minute. Gobara, Geo, that is at page number 5. Gobara Munda. Then number 3.
Sunia Munda, alias Kette.
Right, that is at page 6.
6, man.
Sunia Munda.
This Sunia Munda died since 10 to 12 years.
No, have you noted down in the earlier order about his death? Any order, Mr. Tripathi?
The status report was called for.
No, it's all right. So and so. Agur kichi mention is like.
No, Agur nothing. No, mention.
No. Okay, so where is the instruction region?
Yes.
Where is that instruction, written instruction? Pass it on, you cannot keep it because you have to mention in the judgment that is date. Date since
Since 10 to 12 years ago.
Whose report you are relying for that?
IIC Koida PS.
Koida?
Yes.
Spelling
Koida.
Who
Raurkela.
Sundar.
Raurkela.
Raurkela, Sundargarh district of course. The report पहुंचा है ना तापरे now there are two appellants remains. One is Mangra Munda and the other is Gobra Munda. Okay, these three appellants only face trial or some other?
No, these three appellants.
Three appellants. So they were, you come to the charge portion. Let us see that what were the charges and come to page number. Charge is at page 38.
38.
So 3, yes. Please read the charge. On 3rd October 1999 at about 3 p.m.
3 p.m.
Near Chandi Post
Roadside it commit murder by intentionally causing the death of Keshava Patra, son of late Boida Patra of village Pattamunda, who happens to be Gramarakhi by means of a stone in furtherance of common intention.
Okay, that is one charge. The second charge is?
The second charge, my lord.
Read it out. Same day, time, place, inside the jungle of Chandi Post, knowing or having reason to believe that the offense with murder, punishable with death or imprisonment for life, has been committed, did cause certain evidence of the said offense to disappear and conceal the dead body of the deceased Kesav Patra inside a ditch situated inside the jungle of Chandi Post with the intention of screening yourself from legal punishment. So 201. So these are the two charges.
Yes.
2 charges.
302 and 201, 34. And for both the offenses, the London Trial Court found them guilty.
Guilty.
Right?
Plausible.
Okay.
Now, so, 305 is concerned, life is for sentence, and 201, no separate sentence was imposed.
All right. Come to the FIR then.
Page 16, man. Page 33, running page.
Just a minute. Who is the informant in the case? Karunakar Patra is PW?
PW3.
PW3. Please read out the FIR.
ମୁଁ ଶ୍ରୀ କରୁଣାକର ପାତ୍ର
Hmm.
ପିତା ବିମ୍ବାଧର ପାତ୍ର ସାଇ ବରସିଲା ପୋଷ୍ଟ ପାଟମୁଣ୍ଡା
Hmm.
ଜିଲ୍ଲା ସୁନ୍ଦରଗଡ଼ ଆଜି ତା 4/10/19 ସକାଳ 8 ଘଟିକା ସମୟରେ କୋଇଡ଼ା ଥାନାରେ ଉପସ୍ଥିତ ହୋଇ ଏହି ଲିଖିତ ଅଭିଯୋଗ କରୁଛି ଯେ ଆଜି ସକାଳେ ମୁଁ ମାତାଦିନ ମାଳିଦା ଆଡ଼କୁ ଯିବା ବେଳେ ଚାନ୍ଦିପୋଷ ପାଖରେ ରାସ୍ତା କଡ଼କୁ ପାଟମୁଣ୍ଡାର ଗ୍ରାମରକ୍ଷୀ ଶ୍ରୀ କେଶବ ପାତ୍ରଙ୍କୁ କେହି ଅଜଣା ଲୋକ ମୁଣ୍ଡକୁ ଛେଚି ହତ୍ୟା କରି ମୃତଦେହକୁ ରାସ୍ତା କଡ଼କୁ ପକାଇ ଦେଇଛି।
So that is how the FIR was lodged against unknown person.
Unknown persons.
Okay. Just a minute. FIR date hala given 4/10/1999. Unknown person. Okay. So then how many witnesses were examined?
13.
12.
13.
Okay.
13 witnesses have
Is
been
there
examined.
any eyewitnesses to the occurrence?
No.
No
No
eyewitnesses to the occurrence. The case is based on circumstantial evidence.
Just a minute. No eyewitness. Yes. What are those circumstances?
The only circumstances is the last scene theory. PW 4 and 5.
Last scene of the appellants and the deceased.
Appellants with the deceased.
Okay. Who has deposed about that last scene?
PW 4 and PW 5, my lord. Kindly have a glance.
There is no other evidence like
No other
leading to
evidence.
discovery.
No evidence. No other evidence. Rather, my lord, there is no motive at all.
Mr. Tripathi?
Yes, Miller.
Can I take Mr. there? Can I take that?
We will take up tomorrow, Mr.
We'll
Yeah.
take tomorrow.
Oh, tomorrow, day after tomorrow. Mr. Tripathi, so the learned counsel for the appellant submitted that only material is the last scene.
Last scene.
There is no other like leading to discovery,
No,
extrajudicial confession, any statement by anybody regarding to motive of the crime. There is nothing.
Motive is
has
there.
also not been proved.
Motive is there.
No. Who has the witness?
IO said the motive.
IO
And PW9.
IO motive
Son.
He's the person who has personal knowledge about the motive.
Yes, Miller.
He
PW, the son of the deceased.
তাহলে motive part রে evidence কিଏ କହୁଛି PW9.
Yes, Miller.
Okay. So that is the evidence, right?
Yes, Miller.
What is the weapon of offense?
Stone.
Weapon of offense is stone.
That is also some discrepancies, my lord.
That no, upon you argue, ଆମେ ପ୍ରଥମେ ଜାଣିବାକୁ ଚାହୁଁଛୁ ଯେ ଜିନିଷଟା କ'ଣ ତାପରେ ଆପଣ argument କରିବେ. Stone is the weapon of offense. It was lying at the spot or it was at some other place which
It was lying at the spot.
Okay.
From the spot it was seized.
Okay. Now the doctor who conducted postmortem examination, he is PW
8.
PM doctor
PW8.
PW8. And he what injury he has noticed?
Let's kindly come to page 68, 66.
65.
Running page 66.
66.
Lots.
65, no?
65 lots.
65.
65, sorry.
Just a minute. He is the PM doctor. Okay. So he noticed lacerated wound on the left ear, one bruise on the left forehead, another bruise on the left eyebrow, lacerated wound on the left side mandible. And internal examination, he found that scalp is lacerated, skull is fractured, left temporal and parietal bone fracture. Then, okay, the cause of death he has opined to be due to intracranial hemorrhage, shock, and laceration of brain, right? And the time since death he has given 12 to 24 hours. All the injuries are antemortem in nature, and cause of death is ordinary course of nature to cause death. All right. Then blood stains once is collected. Now the relevant is paragraph number 3. Query made by the IO that whether the injuries found on the deceased is possible by the stone. He opined it in a positive statement that yes, it is possible, and the opinion has been marked as Exhibit 10. But in paragraph 5, he has stated that no stone was produced by the IO before him for examination.
That is there.
Then ये जो खाली गोटे जनरली पचार दीचन तब जे पत्थर रे ही परिवो कि नहीं से कहि दीचन हाँ पत्थर रे ही परिवो.
The stone has also not been produced in the court.
हाँ, but there is a seizure list showing that it was seized.
That is also discrepancies.
Okay.
10 kg ର stone ବୋଲି ସେ କହୁଛନ୍ତି, କିନ୍ତୁ ଯୋଉଥିରେ blood stain
10 kg ର stone ଟା ଗୋଟେ ଏମିତିଆ stone ହୁଏ ଯୋଉଟା କି produce କରାଯାଇ ପାରିନଥାନ୍ତା କୋର୍ଟରେ.
କିନ୍ତୁ ଯୋଉଥିରେ blood stain ଅଛି ଛୋଟିଆ ପଥରଟେ.
ହଁ,
ଯୋଉଥିରେ blood stain ସେ ଲାଗିଛି, that is a small piece of stone.
All right. So now this part is there. We have seen the PM report. Now we'll go to straight to those two material witnesses, 4 and 5, right?
Yes.
The witnesses to the last scene.
Page 57.
PW4 at page
57. Running page
57. Running page 57. Okay. Please read it out.
I know the informant of this case. I do not know the accused person standing in the dock. I know the deceased Keshav Patra, who was working as village
If he
chowkidar.
does not know the accused person, then how can you say about the last scene?
That is corroborated by PW5.
Okay. Yes. Read it. Read it.
I know the deceased Keshav Patra, who was working as village chowkidar. The occurrence took place about 5 years back near village Chandipur. On the date of occurrence at about 3 p.m., when I, along with other co-laborers, were carrying the wedding operation in my land. At that time, I found that deceased was taking 3 persons toward Koida, and also lead that those 3 persons were quarreling with that these 3 persons were quarreling with the deceased in loud voice.
ଜାଗାଟା ଆଗେ କୁହନ୍ତୁ କୋଉ ଜାଗାରେ ଦେଖିଲା?
That is, he found it from the land. That is at village. That is at village
Chandipur. Near village Chandipur.
हाँ, अच्छा. ସେଇଠି ସେ ଦେଖିଲେ.
ଦେଖିଲା ଯେ ସେ ନେଇକି ଯାଉଥିଲେ 3 ଜଣଙ୍କୁ.
ତାଙ୍କ ଭିତରେ ଟିକେ କଳି ହଉଥିଲା.
ଆଜ୍ଞା.
ହଁ, ବଡ ପାଟିରେ. ହଁ, ଉପରେ
I
କଣ ହେଲା?
I cannot say which village these persons belongs to.
Okay.
The road along which the deceased and the said 3 persons were going is at a distance of 70 to 80 cubits away from the place where we were carrying wedding operations. 70 to 80 cubits. The said road leads to Koida through village Chandipur. On the following day, I heard that deceased was killed, being assaulted by his head by means of a stone. In the cross my road that you have stated, I was examined by IO after 1 month of occurrence. I have not disclosed to any of my family members regarding the quarrel took place between the deceased and these 3 persons. While they were passing on the road, Chandipur is at a distance of 1 kilometer from the village. The dead body of the deceased was lying at village Chandipur. The voice from the road is not audible
from our land.
Where we were engaging in wedding work. It is not a fact that I am deposing falsehood at the instance of the police.
So this question was asked because he stated that we had
Proceed.
a quarrel
Quarrel,
between
yes.
them. That is why it was heard that the voice from the road is not audible from our
Awesome.
land where we are engaged. Acha.
And also, it is not his case that one of out of those three persons who were quarreling with the deceased, the appellant was one amongst them. That is not his statement.
They have not stated anything with regard to it.
So it is nowhere related
Okay,
and
all right.
relevant.
No, only thing is that it can
That
be
is
said
corroborated by
we'll
W5.
see, that one particular day PW5 saw the deceased in the company of three
Three
persons.
persons.
And next day he came to know that deceased has died. Okay. Who are those three persons?
Yeah,
Whether it was the appellant or anybody else, evidence is silent. Now the next evidence is
PW5.
PW5. Let us come to that.
And he has stated that only he heard that the deceased was killed by means of a stone.
Right.
He has not stated that I have seen.
No, he has not.
Despite such a statement, he was asked the dead body of this was lying at village so and so.
So even not identified in the court also.
Yes. Next.
PW5.
Hmm.
That Padma
Patra bodhe.
Patra.
Padma Patra.
I know the informant of this case.
Hmm.
I know the deceased Keshav Patra, who is working as police staff. I know the accused person standing in the dock. The occurrence took place about 4 to 5 years back. On the date of occurrence, I, along with PW4, carrying out wedding operation work in the field of PW4. I was engaged as laborer to this wedding work. At about 12 noon, I saw that the deceased was taking three persons towards Koida PS, and they were going through the road which leads towards Koida PS. These three persons were quarreling with the deceased in loud voice. The witnesses identified identified the accused persons in court. These accused persons were quarreling with the deceased while they were being taken to PS by him. The accused persons were working
taken by PS squad.
Yes, that will be.
It's a These occurrence, the accused persons were quarreling with the deceased while they were being taken to PS by him. The accused persons were working as laborer with me at the mines. After finishing the wedding work, I went to my house at about 4 p.m. On the next day, I heard that somebody has killed the deceased, and this dead body was lying by the side of the road which leads to Koida, crossed by the defense.
Okay, has PW4 stated that he was working with PW5?
Yes.
Where is that?
No, he has not stated.
No, he has not stated.
PW4 kahila, I along with other co-laborers were working. So he has not stated PW5 was working with them.
Yes. Co-laborer means he was also working as a laborer.
Yes.
He didn't say that I am the owner of that.
No. See what
But PW5 has stated I was doing a wedding operation along with PW4, who was the in the field of PW4. No, the owner of the field where the wedding operation was going on. Owner of the field.
If the same thing is applied to that from the road, if somebody is on the road, his voice cannot be audible from the. That also applies to PW5 also.
Yes, stated so.
So, how can we say that there was some kind of quarrel between these? Okay, let us go to the cross-examination. What he has stated in the cross-examination PW5?
I used to go to my work in the morning hour, and return home in the afternoon. I have no prior acquaintance with the accused persons. The land,
In
the
question.
land in question where we are taking up the wedding operation is at a distance of 1 furlong from the road. Even if somebody shout loudly on the road, it is not audible to the place where we were working.
So how far you can hear? Yes, next.
It was
Raining
by then. It is not a fact that I have not. It is not a fact that I have not heard the noise. The deceased was distantly related with me as nephew. It is not a fact that I am not engaged as laborer on that day and was not carrying any work on the field of PW4. It is not a fact that I am deposing falsehood.
So this man has seen, let us say that jaha se kahuchi quarrel टाକୁ ଛାଡି ଦିଅନ୍ତୁ जो last scene ଆପଣ ଆଣୁଛନ୍ତି ଯେ ସିଏ କାମ କରୁଥିଲା ଏବଂ 3 ଜଣଙ୍କୁ ଦେଖିଥିଲା ସେ 3 ଜଣ
With
ହଉଛନ୍ତି
company of the deceased.
apparent in the company of the deceased, and next day he came to know that the deceased has
Was
died,
killed,
right?
yes.
So ଏତିକି ହଉଛି evidence.
Yes.
ବର୍ତ୍ତମାନ ଏମାନେ ଯୋଉ ଜାଗାରେ ଦେଖିଲେ deceased in the company of these 3 appellant ଆଉ ଯୋଉ dead body ଯୋଉଠୁ ମିଳିଲା, what is the distance between those 2 places? Distance between the place where dead body was found and the appellants and the deceased were last seen together. କାରଣ ଆପଣଙ୍କର ଦେଖନ୍ତୁ ଡେଡ୍ ବଡି କୁ ପ୍ରଥମେ କିଏ ଦେଖିଲା ସେ ଏଭିଡେନ୍ସ ଅଛି କିଏ ଫାର୍ଷ୍ଟ ଟାଇମ ଡିକ୍ଟେଟ୍ କଲା ଯେ
Yes.
ସେଠି ଡେଡ୍ ବଡିଟା ମିଳିଛି କିଏ who is that witness?
PW informant. Informant PW3.
PW3.
Yes.
Let us see that. କୋଉ ସମୟରେ ସେ ପ୍ରଥମେ ଦେଖିଲା ପଢନ୍ତୁ.
ପ୍ରଥମେ ଲେଖା ହେଇଯାଇଛି I know the informant, but that is I am the
But he is the
informant.
informant inadvertently.
Lordship. I know the accused person standing in the dock.
କୋଉଟା ଜାଗାରେ ଆମ ହବ.
Lordship.
Okay, all right. ହଁ.
I know the accused person standing in the dock. I also know the deceased Keshav Patra, who was the Gramarokhi of village Otamunda.
The occurrence.
The occurrence took place in the year 1999, and I reported the matter in writing on 4/10/1999 at Koira PS while I was proceeding towards Hatodihi Sarada mines on the way about 9 a.m. Near Chandi Post, I noticed that the deceased was lying dead by the side of the road and found bleeding injury on his head. Then I reported the matter immediately at the PS.
So the dead body was lying at Chandi Post, right?
Yes.
Dead body lying at Chandi Post. ଏମାନେ କୋଉଠି ଦେଖିଲେ?
By the side of road.
By the side of road while they were working in their field, they found.
ନାଇଁ ଏମାନେ ଯୋଉଠି ଦେଖିଲେ ସେ ଜାଗାଟା ନା
କଥା କହିନାହାନ୍ତି they only heard. ଆମେ ଶୁଣିଲୁ ସେ ମରିଯାଇଛି ଦେଖିବା କଥା କହିନାହାନ୍ତି.
ମୁଁ ସେ କଥା କହୁନି ଯୋଉ ଲାଷ୍ଟ ସିନ୍ ଯୋଉ
ପାଟିତୁଣ୍ଡ କଥାଟା ସେ କହିଛନ୍ତି ଚଣ୍ଡୀ ପୋଷରେ ଆମେ
Chandi post. Same place.
but so far as the dead
on
body
the
is
date of
concerned,
occurrence so I along with so was carrying weeding operation in my land at that time. ତାଙ୍କ ଯୋଉ land ରେ ସେ କହୁଛି ପୁରା occurrence ଟା ହେଲା ଚଣ୍ଡୀ ପୋଷ ରେ ଇଏ କହିଲା ମୁଁ ଆମ ବିଲରେ ଆମେ କାମ କରୁଥିଲୁ ହେଲା ସେଇ ଯୋଉ ବିଲଟା ତାଙ୍କର କୋଉଠି ଇଏ ତ ଆ ଘର ହଉଛି ଦେଖନ୍ତୁ ଆ ଘର ହଉଛି ବାଲଡିହି ମାନେ PW4 ର ମୌଜା ଲେଖା ହେଇଛି ବାଲଡିହି 5 ର ଲେଖା ହେଇଛି ବାଲଡିହି ତେଣୁ ତାଙ୍କର ଯୋଉ ଜମିଟା एटा बाल्डीही रे ना
चंडीपोस रे
कोड पाइले
that is there in there in the statement of PW4 my lord.
कोड बापा बाहर करले
On the date of occurrence at about 3 p.m.
हां
while I along with the other laborers were carrying the wedding operation in my land at Chandi at
Good.
that time I found that at my land sorry.
कोड लिखाइए डोंट टेक एवरीथिंग
Wedding operation in my land.
My land.
ये यार लैंड टा कोठी
That is not there.
हां घटनाटा चंडीपोस रे ହେଇଛି मिस्टर त्रिपाठी
Lordship, my lord, lordship.
घटना चंडीपोस रे ହେଇଛି एमाने आंको बिलरे काम करूथिले आंको घर होची बाल्डीही
बाल्डी।
बाल्डी क्लियर PW4 रो भी बाल्डी
Both are belongs to Baldi.
हां दी जनकर बाल्डी तेणु बाल्डीही रु से जो चंडीपोस जदि भी आंको जमीटा मनकर बाल्डीही रे हेतिबो इट मे नॉट बी आल्सो से माने तांकर बाल्डीही रे जदिओ तांको घर हुए तो अन्य जगह रे ही थाई पारे जमी माने जोठी से माने ये करथले तेणु वेयर इज दैट प्लेस वेयर दे वर कैरिंग आउट द wedding ऑपरेशन
And along with PW4, two others were engaged.
अच्छा
wedding
एठी गोटे
operation.
लाइन टे बाहर ची क्रॉस एग्जामिनेशन ले दैट चंडीपोस इज एट ए डिस्टेंस ऑफ 1 किलोमीटर फ्रॉम आवर विलेज
PW4.
PW4 क्रॉस एग्जामिनेशन बाहर
Lordship.
बट अगेन वी आर आस्किंग यू दैट हे जो जमीटा कोन आंको गां रे थिला ना अन्य कोठी थिला से एविडेंस काहे कारण गां रे जदी अछि ठीक अछि ए डिस्टेंस टा गोटे किलोमीटर चलिबो बट इफ दी they
You
were
keep-
carrying out the wedding operation in their land which is situated at some other place
Yeah, that is PW5 minute.
कोना दी कोडी
Here is the cross examination.
Hmm.
The land in question where we are taking of our wedding operation is at distance of 1 furlong from the road.
रोड माने जोडी से जो कळी सुनिले
हाँ ताठू तांका land टा होची 1 furlong.
जोठू जोटी चाष करूथिले सेई जोठू जो जगह रे डेड बॉडी मिलिला सेटू मने करो आंकर आर गां होची गोटे जगह
Yes,
क्लियर गां होची दी जनकर बाल्डी
Baldi.
राइट
Yes.
एवं डेड बॉडी मिलिला कोठू ना डेड बॉडी मिलिला चंडीपोस ठीक अछि
रास्ता कड़ू।
रास्ता कड़ू बाल्डीही चंडीपोस डिस्टेंस होची 1 किलोमीटर ठीक आमे वी आर लुकिंग इनटू दी दैट एमाने देखा हले कोठी ना जमी रे गोटे पर्टिकुलर जमी
Jami.
से जमीटा जदी लेट अस से बाल्डीही रे हेतिबो इज ऑल राइट बट it is not necessarily that that land would
Land
be at
would be-
Baldi
yes.
हैला so it may be at some other place तेणु जदि अच्छा नेक्स्ट थिंग इज दैट ये तो कहिला जे मु घटना परे मासे परे स्टेटमेंट देबे
Yes.
PW4 व्हाट अबाउट PW5
ताकू पचरा हेनी.
से विषय पछे
नै हेनी जे हमरो
161.
161 ने केबे बा आईओ किछि कहूची की मे मान के दी जणु केबे एग्जामिन करली
PW13
हम
PW5 has stated, I have no prior acquaintance with the accused person. So then how he could recognize them
say doc
in court?
in the court
Court,
Yes,
in the
how he
court.
could?
because he found that there is a dispute.
How?
Well-
When he stated in the cross-examination that I have no prior acquaintance with the accused persons, how he could
तांको
recognize them?
कारण ए जो माने
दूररे घटिची।
नै नै नै
लोक सारे-
सी डिपोज करूची आफ्टर 5 years of the occurrence
Yes.
that line comes in page 57
Approximately.
fourth line the occurrence took place about 5 years back in village Chandipur तेणु जहा संगरे आगु संपर्क नथिबो acquaintance
ताकु
नथिबो ताकु 5 वर्ष परे for the first time court identification करिवो ताकु how far it will be acceptable that is one thing and number thing you just find out that when that statement actually of PW4 and 5 were recorded कारण जदि सेमानको ज्ञान को आसिला जे आमे सेई पितवास को जहा को आमे बिलो पाखरे रास्ता ऊपर जीवा को देखुथिलु 3 जण लोकन संगे ता डेड बॉडी टा पड़ी रास्ता कड़े तो दे शुड हैव वॉलंटियर टू मेक सच स्टेटमेंट जे तीनटा लोक सांगरे आमे देखिथिलु तांकू तेणु सेमाने के दिन परे ए विषय डिस्क्लोज कले व्हेन देयर स्टेटमेंट्स वर रिकॉर्डेड ए 161 बाहर कलो केस डायरी बाहर करो ये जो स्टेटमेंट बाहर करो गोटा ना शक्ति पात्र आ गोटा ना पद्म सती पात्र पद्म पात्र बाहर करो हाँ सती पात्र सती पात्र है PW4 PW4 सती पात्र ता स्टेटमेंट के भेची 5/10/1999 right it was next day of the lodging of the FIR. Then what about the other one? आरटा बाहर करो तारो 5 नंबर साक्षी होची पद्मा पात्र PW5 5/10/1999 ये भी say 5/10 whereas the witness PW4 at least stated that I gave my statement on 1 month after the occurrence. अच्छा PW5 रो स्टेटमेंट पद्मा पात्र स्टेटमेंट देखंतु कौन से कहूची मोर नाम पद्मा पात्र आज हाजर होई जमानबंदी देउची 3/10/2019 तारीख मु आम ग्रामर सती पात्रंकर घास सफा करिया पई जाइतिली सती पात्र माने PW4 अच्छा माने जमीटा होची PW4 रो घास सफा करिया पई जाइतिली सती पात्र मध्य आम सहित मिसी गाँ शेषरे थिबा तांको जमीरे घास सफा करुथिले दिन प्राय 3टा बेलू पाटमुंडेर गाँ चौकिया केशव पात्र 3 जण मुंडा पिलांकू धरी रास्तारे पाटितुंड करुथिबार आमे देखिलु सेमानक कथारु जणा पडुथिला सेमानकू केशव थाना को नहीं जाउथिला हेले रास्तारे सेमाने पाटितुंड करी कहउथांती आमे थाना को जीवु नाही आमे कोन चोरी करिछु बोली सेमाने कहउथांती समस्ते पी थिबार जणा पडुथाय बहु समय धरी रास्तारे पाटितुंड करी सेमाने आड़ को गोटे लिखाई चाली कोईठा ना कौन कोईडा अच्छा कोईडा आड़ को चली गले आम जमी रे काम सारी घर को फेरिलु गतकाली सकाळे आमे खबर पाइलु जे कोनोसी लोक केशव मुंडा को पत्थर रे छेची मारी ताकू चांदीपोष रास्ता कड़े पकाई देइछि उपरोक्त 3 जण मुंडा पिलांकर ना मध्य मु जाने सेमाने काटे मांगीरा पुरा कारण सेमाने पाखो माइंस रे काम करंती ए जो स्टेटमेंट एटा देला इट इज कंप्लीटली डिफरेंट इन दैट
डिपोजिशन गिवन
डिपोजिशन रे कहला कोन ओडे
आई हैव नो प्रायर अकॉर्डिंग
नो प्रायर अकाउंटेंट्स विथ दिस आंसर एठी ता ना कहूची जे सेमाने काम करथले माइंस रे सेट पई 5 ना वो तो टोटल नाही हो इडो पद्मा पद्मा पात्र तो एटा ए टाइप रो जदी एविडेंस आसिला 4 and 5 रो particularly when law is very clear that last sin is itself cannot be a factor to convict unless से टाइप रो क्लोज एविडेंस न आसिला पर्यंत आपनकर लास्ट सीन टा हेइथिबो जो जगह रे डेड बॉडी सेही जगह रे इमीडिएटली जदी रेस्क्यू हबो ताहले ताकू गोटे सर्कमस्टांस हिसाब रे नियाई परिबो जदी देयर इज टाइम गैप and there is possibility of other persons coming in between कारण एठी आपनकर 4 तारीख दिन 3 तारीख दिन 3/10/1999
अपराह्न सेमानेंकर दिन 3टा बेले लेट अस से 3 PM सेमाने गोटे जगार एकाठी देखा जाउछन ता पर दिन 4/10/99 9टा बेले अकॉर्डिंग एज पर द एविडेंस ऑफ PW3 हां 3टा पर अपराह्न
सेटा भी डिस्क्रिपेंसी देयर आर सम डिस्क्रिपेंसी
एगुरा कोन 3टा बेले दिन
12ଟା
12टा बेले आ एवं ता पर दिन PW3 सेमान को देखिला केबे 9टा
बेले
4ଟା दिन 9ଟା ବେଳେ
9 PM
next
so 9 AM sorry 9 AM means that is time gap almost 18 hours तेणु persons coming in between cannot be ruled out ये गोटे गला बाकी आउ कोन रहला आपनकर
so far my submission is concerned my lord that there is no motive is not at all
ने क्वेश्चन पर PW9
No, sorry, 10. PW10.
PW10
Yes,
देखा
son.
कौन मोटिव विषय कौन को
But PW4 has not stated that PW5 also was doing wedding operation with him.
no she has not stated
He
it
said some other co-workers were doing wedding
she has
operation
not stated
with
the
him
name of that
in
PW
his field.
ये जो स्टेटमेंट आपनकर आसिला जे तांको भीतर कळी करथले एवं एई पर्टिकुलर रीजन पई कळी करथले सेटा रीजन टा मध्ये नाही एमानकर दी जणक एविडेंस खाली अछि कळी
Yes.
बट अगेन इफ वी सी दैट इट इज नॉट ऑडिबल फ्रॉम दैट पर्टिकुलर फेस से कळी करथले बोली खाली जहा जदी देखा जाउथियो भी से गोटे गेस वर्क करथियो बट कळी करथले कि कोन तांको भीतर होतला बिकॉज़ इट इज नॉट ऑडिबल फ्रॉम दैट
Both PW4 and 5 have admitted in their prosecution that it was not audible.
So let us come to PW10 about that motive part you are telling.
Ken is the son of the deceased
Son of the page 70.
What he has stated, please read, Mr. Tripathi.
Proceed, madam. I know the informant of the case. I know the accused person standing in the dock. The deceased Keshav Patra is my father. The occurrence took place on 3/10/1999 at village Baldihi roadside. My father was working as a Gramolokhi. On 2/10/99, my father had received a notice from Koira PS to take the accused persons, namely Kate and Gobara, to police station. On the next day, my father went to village Padadihi and came back to our house along with all the accused persons at about 1 PM. Thereafter, my father took his meal and the accused persons drank handia, being served by my mother. Then they all left for Koida PS, including my father. On the next day morning, I got the information that my father lying dead.
So this is also one sort of last scene. It is
Last
not
scene.
that.
Yes.
But he has heard it, madam.
Good.
এই যে পার্টটা মরিবাটা জিবাটা ঘরু খালি দেখিছি
মরিবাটা আমি কহু এই যে
লর্ডশিপ
last scene he is also a witness. On the next day, yes, read it out.
On the next morning, I got the information that my father was lying dead by the side of the road near Baldi village, and getting information, I rushed to the spot and found my father lying dead with bleeding injuries on his head. Then police came to the spot and I held inquest over the dead body of the deceased in my presence and prepared the inquest report. This is the said signature. This is the said inquest report, which is marked as Exhibit 11, and Exhibit 11/1 is my signature there. Cross, madam. Our village is at a distance of 3 kilometers away from village Padadihi. The accused persons are resident of village Padadihi. At about 11 to 12 AM, the IO held inquest over the dead body. Then the dead body was sent for PM examination to Koira hospital. I also accompanied the dead body. I returned to my house in the evening. On the same day, I was examined by the IO at spot before my visit to hospital. I have not read content of the notice. I have not seen the notice. Later on, I came to know that the contents of the notice is not notice. It is not a fact that nobody had giving any notice to my father, nor my father went to village Padadihi to call the accused persons. It is not a fact that I have not seen the accused persons along with the deceased, and then I am deposing this, and that I am deposing falsehood.
That particular notice has been proved in this case.
That IO has stated me.
That is that is also been exhibited by.
Let us see that IO's evidence.
13. That's page 77. Yes, at para 4 million that he has stated. On the same day at 12 noon, I seized the letter which was issued to the deceased by me with a direction to produce accused Ketemunda before me and also seized one stone. What is it? The sign.
Ketemunda ki?
Ketemunda hauchi appellant number 2.
Apran number 2 hela Gobor Apran.
Kete is that appellant number 3.
Apran number 3, which date?
Date.
So that was not a notice for the other two appellants.
No.
So if that is not a notice, so why he will take them also to the police station?
They accompanied with that.
No, the son statement you see,
Hmm.
this is completely contrary to 7/2. So this is the notice issued already marked as 7/2. A 7/2 da marka notice ta exhibit list. This is 2. The 3. Wait. This is 4. Then the 4 part. Bro. Right, how is it? 5. 5. Page number 53. So now that's 53. Give it 7. I said. गोटे थाना जाइथिबा हाथ लेखा चिठी ओ काटे मिंडा को डाकी आनिबा पई दिए जाइतिला खाली एति लिखा जाओ किछि लिखा से डॉक्यूमेंट ही नहीं. This is the said notice issued by me on 2/10/2099 already marked as exhibit 7/2 and exhibit 7/5 is my signature. 7/2 ta pora. The 8 PM report. 7/2. 7. Hey, देखी 7/2, 7/5 कौन? 7/2 रे तो ये signature का 7/5. ये 7/3. एक के 3 याद रखी. ना वो डॉक्यूमेंट थी वो. ये जो डॉक्यूमेंट था थोड़ा सी बात है. एटा PM रिपोर्ट था. या नंबर और था. एटा से PM रिपोर्ट. एटा 9 है सर अच्छी ये हार्ड कॉपी अच्छी. ऐसे देख ली 7/2 था. मन इच्छा और नहीं ये स्कैनिंग ठीक से होनी ना. चिट्ठी अच्छी Five by two. It is 7 down. 7. It also exhibit 7. 7 by 3. Okay, 7 by 4 भी है. 7 by 2 बोला 5 से दिखाको ये जो document है ये गोटा ये particular missing माने से originally এটা করা हाँ ये पठिने but evidence IO ଆସୁଛି ଯେ ଜଣକୁ କେବଳ ଇଏ ତାଙ୍କୁ ହାଣ୍ଡିଆ ସର୍ଭ କଲା ବାଟରେ so far as the intention of killing is not coming out of the evidence of this PW10, that as because his father forcefully took them to police station, being so summoned by the IAIC, they killed. Rather, he's saying my mother served handia to them.
That is there. PW11 is the mother, wife.
What she has stated? Nobody has
No.
alleged that we apprehend that they might have murdered. Nobody has stated.
They apprehend that the police will beat them.
Now, first of all, when the notice was only issued against Sunia Munda alias Kate,
Yes.
that is the evidence of the IO.
Yes.
Then doubt crops up that why
the other two persons should accompany.
No, before my humble submission, my lord, before entering to that fact, my lord, I think it is necessary to go to para 2 of the paper book, because the fact is something different. With regard to sharing of fixed, my lord, on 211, there is a dispute between appellant number 1, that Mongara and Sonia. ସେମାନଙ୍କ ଭିତରେ ମାଛ କଣ୍ଟାକୁ ନେଇକି ଯେତେବେଳେ ଗଣ୍ଡଗୋଳ ଲାଗିଲା, the Sonia Tete went to police station. ସେଠି କହିଲା ଯେ ଆମ ଭିତରେ ଗଣ୍ଡଗୋଳ ହେଇଯାଇଛି, ତମେ ଡାକ ସୁନିଆକୁ ଡିସାଇଡ୍ କର। ସେ ଟେଟେ ହାତରେ ଆଇଏସି ଗୋଟେ ଚିଠି ଲେଖିକି ପଠେଇଦେଲେ ଗ୍ରାମରକ୍ଷୀକୁ ଯେ ତମେ ଧରିକି 2 ଜଣଙ୍କୁ କାଲି ଥାନାକୁ ଆସ। ଗ୍ରାମରକ୍ଷୀ ଆସିଲା ବେଳକୁ ମଙ୍ଗରା ମୁଣ୍ଡାର ଭାଇ, that appellant number 2 ଗୋବରା ମୁଣ୍ଡା, no way concerned, ସେ ବି ତାଙ୍କ ସାଙ୍ଗରେ ଆସିଲେ। 3 ଜଣ ଯାକ ଗଲେ ଥାନା, 3 ଜଣ ଯାକ ଗଲେ to the house of that ଗ୍ରାମରକ୍ଷୀ। ସେଠି ଗ୍ରାମରକ୍ଷୀ ତାର ଖିଆପିଆ କଲେ, ହାଣ୍ଡିଆ ପିଇଲେ, ହାଣ୍ଡିଆ ପିଇକିରି 4 ଜଣ ଯାକ ଯାଉଥିଲେ ଥାନାକୁ। and that is on the way PW 45 ଦେଖିଲେ ଗଣ୍ଡଗୋଳ ଲାଗୁଥିଲେ। next day morning the dead body was found.
ଏଗୁଡା ପାଇଲେ କୋଉ?
ସେ ପାର୍ଟଟା that is there in paper book 2, ନହେଲେ ଏ ଫ୍ୟାକ୍ଟ ଗୁଡାକ କେହି ଆଣି ନାହାନ୍ତି। page my lord, page 9.
Page 9.
Lordship my lord of the paper book.
PW 11 somehow stated
that has only been stated in that in paper in para 2, but with regard to that no question has also been asked to anybody else.
No, କୋଉଠୁ ପାଇଲେ ଏଇ ଯୋଉ
PW 11 में para book एक रुको
PW11?
Wife of the deceased.
କଣ ହେଲା ପଢୁନାହାନ୍ତି?
Listen, I know the informant of this case. I know the accused person standing in the dock. The deceased Keshav Patra is my husband. The occurrence took place about 5 years back at about 3:30 p.m. at Baldihi. On the alleged date of occurrence, the accused Mongara Munda came to our house in the morning with a notice from Koira police and delivered it to my husband, deceased husband. Then my deceased husband told the accused Mongara to go to the village Podadihi to call other 2 accused persons, as they were required by the police as per the notice, since a quarrel had taken place between the accused Mongara Munda on one side and other 2 accused persons on the other side. After a while, after taking tea, my deceased husband left the village Podadihi to call the accused persons. At about 3 p.m., my deceased husband came to our house along with the accused person and instructed me to serve them food. On being instructed, I served country rice beer and 1 plate of chicken to the accused person. After taking their meal, the accused person, being accompanied by my deceased husband, went towards Koira PS.
So she is also a witness to the last scene.
Last scene.
ଆପଣ କହିଲେ 4 5 ଏଗୁଡା ସବୁ ଲାଷ୍ଟ ସିନ୍ ରେ କହୁଛନ୍ତି ନା? ଏବଂ ବାହାରିଲେ yes, ତାପରେ କଣ ହେଲା?
While they were proceeding towards Koira police station at the place of occurrence under a banyan tree, the accused Sonia Munda and accused Gobra Munda, who were 2 brothers, assaulted my deceased husband by means of a stone, apprehending that they were taken to the PS by the deceased and they would be beaten by the police. Initially, Mongara Munda did not join with them in the assault, but these 2 accused persons threatened him if they would not participate in the assault, he would be killed by them. Thereafter, he also joined his hand along with other 2 accused persons on assault. Due to the attack by the accused person, the deceased died on the spot. On the following day morning, I received information about the death of the deceased.
He has no personal knowledge.
No.
As if she has seen the occurrence,
yes,
she has
yes.
stated like that.
And there also he has stated,
No, but his son has stated that they came to their house at around 1 p.m., whereas she has stated that they came about 3 p.m. Yes, what she has stated in the cross-examination.
Lordship, I have no direct knowledge about the occurrence.
No, sir. Before that, para 4.
Para 4. Cross-examination.
By FPP. And
154, the hostile. It is a fact that I have stated before the IO that on the alleged date of occurrence about 1 p.m.,
While the accused person along with my deceased husband left for PS, the accused Ketemunda, Gobramunda were telling that today they would make final of the matter on the way. And that my deceased husband was telling that whatever would be decided, it would be decided at PS. And that the accused person left our house making hue and cry, that I have stated to IO that my deceased husband had to go to the Tensa on the same night after visiting Koira police station, and that for that we did not search for him on the same night.
Cross examination போடும்.
Proceed. I have no direct knowledge about the occurrence. My house is at distance of 4 to 5 kilometers from the spot. On the same day, I was examined by the IO Koira PS. Is at a distance of 3 kilometers from our village, Potta Munda. Village Baldi and Teheri intervene between village and Koira. On the relevant time, there was no conveyance facilities from our village to Koira. Sometimes we used to go to Koira by different types of vehicle and also by walk. The accused Kete and Gobra used to call Mamu to the deceased, and they were having good terms with the deceased. It is not a fact that I have not stated to the IO that the accused person came to our house about 3 p.m. I cannot say the native of the accused person. It is not a fact that I see the accused person today in the court for the first time. It is not a fact that I do not know the parents of the accused person and about their family members. The father's name of the accused Kete is Choitu Munda. It is not a fact that I have not stated to the IO that on the alleged date of occurrence about at 3 p.m. I served the handiat and chicken to the accused person being instructed by my deceased husband, and that the accused person Sunia and Gobra assaulted the deceased by means of stone, and the initially accused Mangramunda did not join with them, and that thereafter joined with the other accused person and participated in the other being threatened by the other two accused persons, and that I heard the matter from the Krishna Patra,
Krishna Patra, village Baldi.
village Baldi. It is not a fact that I am deposing false.
But that Krishna Patra has not been examined. He is not a witness.
Have you brought any decision on last scene?
So for the last scene is concerned, my lord, that I have not taken, but so far the motive is concerned, that one instruction I have got.
The entire case is based on last scene,
Last
and
scene
you are
upon.
not bringing any citation.
PW 10 and 11.
Five,
4, 5,
5, 10.
five witnesses have stated about last scene.
4, 5, 9, 10, 11. 9 भी ଅଛି. 9 कौन कुछ? 9 going.
4, 5, 10, 11. Mine supervisor, he also saw them on the way.
Yes. Married.
Honda.
PW 9.
Page
68.
68.
Yes.
Who is that witness?
That is one mine supervisor. Clerk at OMM Private Limited. I know the informant of the case. I know the accused person standing in the dock. I also know the deceased S.K.SAHOO Patra, who was the grammar Rakhi.
Just a moment.
Yes.
Please wait.
District.
PW 9, my lord. Mohan Charan Das.
Yes,
Yes,
proceed.
proceed.
I know the informant of this case. I know the accused person standing in the dock. I also know the deceased Kesapatra who was the Gramaraki. The occurrence took place one day in the month of October in the year 1999. At the relevant time, I was working as a mine supervisor in the office of mines at Patamunda. On the earliest date of incident, at about 11 a.m., the deceased came to me, being accompanied being accompanied by accused persons, and approached me to provide a dumper so as to carry the accused persons to Koira PS, as they were required by the police. But I expressed my inability to provide the dumper as there was no availability of the dumper. Then they all left. At about 3:30 p.m. on the same day, while I was coming to Koira with a water tanker on the way near Baldi, I found the deceased along with the accused persons moving towards Koira, and seeing them, I called them to go in the said tanker, but they did not agree and told me to go by walk. Then I left for my destination. On the next day morning, while I was going to Koida to Patamunda in a commander, I heard that the deceased had been killed and the dead body was lying by the side of the road near Baldihi.
So
Cross-
again, this witness also stated about the last scene. So at least Mr. 4, 5, 9, 10,
10,
and
11.
11. Okay. They at least they on the previous day of the dead body was found. All of them have seen the
The
deceased company with the
Three
no,
accused.
even if PW4 of 5 was not stated specifically regarding, but 9, 10, 11 have stated that it was they have seen it.
Yes.
And the question again comes up that whether this last scene which was there and the dead body was found, that can be itself sufficient for convicting the rape.
And he has stated in his examination sheet that the deceased
এটা কোন চালু নেই?
came to him along with the accused person, approached him to provide him a
Yeah,
dumper.
vehicle, yes.
It's a heavy, hard-moving vehicle to be provided for carrying them to the police station. Unbelievable. Dumper, where this earth is being carried out.
See what is the decision says. It's clear from the above that where there are other links have been satisfactorily made out. The circumstance point to the guilt of the accused. The circumstance of last scenes together and absence of any explanation would provide an additional link which completes the chain. In the absence of the other circumstance, the only circumstance of last seen together and absence of satisfactory explanation cannot be made the basis of conviction. The other judgments on this point that are cited by so do not take a different view and they need not be adverted to. He also relied upon a judgment of this court in State of Goa versus so in support his submission that the circumstance of last seen together would be a relevant circumstance in case where there was no possibility of any person meeting or approaching the deceased at the place of incident or before the commission of crime in the intervening period. It was held in the above judgment as follows. from the principle laid down by this court, the circumstance of last seen together would normally be taken out of consideration for finding the accused guilty of the offense charged with, when it is established by the prosecution that the time gap between the point of time when the accused and the deceased were found together alive and when the deceased was found dead is so small that possibility of any other person being with the deceased would be completely ruled out. Like गोटे घर भितर स्वामी स्त्री अछंती हला तापरे तार डेड बॉडी मिलुची short time. So the time gap between the accused person seen in the company of the deceased and the detection of the crime would be a material consideration for appreciation of the evidence and placing reliance on it as a circumstance against the accused. But in all cases, it cannot be said that the evidence of last seen together is to be rejected merely because the time gap of the accused persons and the deceased last seen together and the crime coming to light is after a considerable long duration. There can be no fixed or straitjacket formula for the duration of the time gap in this regard, and it would depend upon the evidence laid by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period. That is to say, that if the prosecution is able to lead such an evidence that other person meeting the deceased in the intervening period, that is to say, if the prosecution is able to lead such an evidence that likelihood of any person other than the deceased being the author of the crime becomes impossible, then the evidence of circumstance of last seen together, although it is a long duration of time, can be considered as one of the circumstance in the chain of circumstance to prove the guilt of the accused persons. Hence, if the prosecution proves in the light of the facts and circumstance of the case that there was no possibility of any person meeting or approaching the deceased at the place of incident before the commission of the crime in the intervening period, the proof of last seen together would be relevant evidence. For instance, if it can be demonstrated by showing that the accused persons were exclusive possession of the place where the incident occurred and where they were last seen together. এই ঘরটা মনে করো, so এইଠି last seen ହେଲା, এই dead body ଟା ମିଳିଲା, ଆଉ ଏଠି ଆମର କେହି ଆସିବାର ହିଁ possibility ନାହିଁ, and there was no possibility of any intrusion to that place by any third party, then a relatively wider time gap would not affect the prosecution case. ହେଲା ତେଣୁ ସମାନ ସବଷ୍ଟାନ୍ସ ସେ କହୁଛନ୍ତି ଯେ ଯୋଉଠି ଅଦର ସର୍କମଷ୍ଟାନ୍ସ ଥିବ ଲାଷ୍ଟ ସିନ୍ ଟା ଗୋଟେ ଆଡିସନାଲ ଇଏରେ ନେଇଯିବ, ତମେ ଅନ୍ୟ କିଛି ନାହିଁ ଲାଷ୍ଟ ସିନ୍ ବେସିସ୍ ରେ କରିପାରିବ ନାହିଁ ଯୋଉଠି ପର୍ଟିକୁଲାରଲି ଅଦର ପର୍ସନ୍ସଙ୍କର ଡିସିଜ୍ ସହିତ କଣ୍ଟାକ୍ଟ ର ପସିବିଲିଟି ଅଛି। ହେଲା ଏଠି ଯଦି ଆମେ ଗୋଟେ ହାଇପୋଥେଟିକାଲି ନବୁ, ମନେକର ଲେଟସ୍ ସେ 3 ଜଣ ଯାଉଥିଲେ କାହା ସାଙ୍ଗରେ ନା ଡିସିଜ୍ ସାଙ୍ଗରେ, କିଛି ବନ୍ଧା ହେଇକି ତ ଯାଉନଥିଲେ, ଯାଉଥିଲେ, ମନେକର ଲେଟସ୍ ସେ ବାଟରେ ଦେଖିଲେ ଇଏ ଏକୁଟିଆ ଅଛି, 3 ଜଣ ଯାକ ଖସି ପଳେଇଲେ, ତାପରେ ଡିସିଜ୍ ଲୋନ୍ ରହିଗଲା। ହେଲା ତ ଡିସିଜ୍ ର ସେଠି ପସିବିଲିଟି ଅଛି ଅନ୍ୟ ଲୋକଙ୍କ ସଂସ୍ପର୍ଶରେ ଆସିବାକୁ, ସେମାନେ କ୍ରାଇମ କମିଟ କରିବାକୁ। ତେଣୁ ହାଉ କ୍ୟାନ୍ ୟୁ ସେ, କାରଣ ସେମାନେ ଲାଷ୍ଟ ଦେଖା ହେଇଥିଲା ତାଙ୍କ ଘରେ ଯେତେବେଳେ ଦେଖା ହେଲେ ସେ ଯୋଉ ପଡିଆ ପାଖରେ ଦେଖା ହେଇଥିଲେ ଫିଲ୍ଡ ପାଖରେ, ଯଦି ଆମେ PW4 ଆଉ 5 ର ଏଭିଡେନ୍ସ କୁ ଆକ୍ସେପ୍ଟ କରିବୁ ତାହେଲେ ଦେଖା ହେଇଥିଲେ 3ଟା ବେଳେ, ଅପରାହ୍ନ 3ଟା ବେଳେ ଦେଖା ହେଇଥିଲେ, ଆଉ ଗୋଟେ ଅବଶ୍ୟ କହୁଛି 12ଟା 1 ବେଳେ, ଧର 3ଟା ବେଳେ, ଓର୍ସ କେସ୍ ହଉଛି 3ଟା ବେଳେ, ତ 3ଟା ବେଳେ ସେମାନେ ଦେଖା ହେଲା, ସେମାନେ ଯାଉଛନ୍ତି ଗୋଟେ ଜାଗାକୁ, ତା ପରଦିନ ଆଉ ଗୋଟେ ଜାଗାରେ ଦିନ 9ଟା ବେଳେ ଡେଡ ବଡି मिलिला तेणु आ भितरे आमे जदि गैप देखुचु 18 घंटा टाइम गैप आसुची तेणु the place where the dead body was seen is at a different place and the possibility of ei jo principle ko ame jodi nabu the possibility of the other person coming in contact with the deceased cannot be ruled out ତେଣୁ ଏଇ circumstance
Time.
time
The
18 ଘଣ୍ଟା ହିଁ
postmortem report, the time of death,
ହଁ
18 to 24 hours.
କଣ ହେଲା
Doctors say.
ହଁ
Dead body मिलला ପରେ postmortem ହେଲା ପରେ
पोस्टमार्टम आपण टाइमिंग केते देखुनांती पोस्टमार्टम सिना you come to the PM report the doctor is PW
8 madam. ସେଟା ତ ଲିଭି ଯାଇଛି ନାଇଁ କଳା ହେଇଯାଇଛି।
ହଁ ଡକ୍ଟର ତାଙ୍କୁ ପୋଷ୍ଟମର୍ଟମ ଏକ୍ସାମିନେସନ କରିଛି 4 ତାରିଖ ଦିନ ସୋ ଦି ଟାଇମିଂ ଆଜ ଫର ଦି 4 ତାରିଖ ଦିନ 1:30 ରେ କରିଛି ହେଲା ଆମେ ଲେଖି ଦଉଛୁ ଡକ୍ଟର PM କରୁଛି 4/10/1999 ଆଉ ଟାଇମ କହୁଛନ୍ତି ଡେଟ୍ ଅଫ ଟାଇମ ଅଫ ପୋଷ୍ଟମର୍ଟମ ହଉଛି 1:30 ବେଳେ ହେଲା and his report is that the death has taken place jodi se ako
Yes, 12 to 24 hours.
12 to 24 hours tenu ता माने डेथ टा हेइथिबो केते बेले ना 12 जदी हबो ताले राती 1:30 रु 3 तारीख 3/10/1999 दिन 1:30 रु हला राती 1:30 भीतर हेइथिबो नुहे कि
12 hour ହେଲା
अपन बा कहले माने 12 रु 24 घंटा भीतर परा 12 to 14 24 आवर्स हेलानी माने ये जदी 24 आवर्स हे गेले आसी गेला 3 तारीख दिन 1:30 तेणु दिन 1:30 रु 3 तारीख दिन राती 1:30 भीतर घटनाटा है राइट ये माने देखा होची केते बेले ना 3टा बेले 3 तारीख दिन 3टा बेले घटना देखा तेणु जेहेतु ता भीतरे मरिवा भीतरे ता परे मध्य टाइम गैप रहउची 3:30 रु एटलिस्ट 10 घंटा टाइम गैप रहउची तेणु हाउ डिड यू tell with certainty that in between that period there was no chance of anyone coming in contact with the a decision ta apan note kar dei thantu will that judgment ame court re daki debu pahar dino because there is no time today
yes
a decision ta hoshi tadre sabu tak last scene no bahut bhalo bhalo judgment guda ko sabu court heichi gudai judgment so the
goa
nahi seta bi seta site heichi you mention it is a citation last scene ro eta hochi Anjan Kumar Sharma versus state of Assam hala and the citation is 2017 volume 14 SCC 359 बही मगे कि रखि हला सोमवार दिन ए गुरुवार दिन and it is also reported in AIR so AIR 2017 Supreme Court 2617 तदरे गुडा डिसीजन दे so एठी फर्स्ट आवर रे पहर दिन LCR आसी पहुंची थियो हला somebody should immediately be informed he will carry the LCR original LCR हला आउ henceforth जो केस रो सुनानी हो तो तार जो ओरिजिनल record नथिबो I will take action against you okay yes so मोटिव टा जोटा आपण कहउचंदी मिस्टर त्रिपाठी
yes
मोटिव टा जो कहउचंदी जो तांकु डकै कि नेला एई जदी एविडेंस हबो तारे आपणकर आगुरु देखुन से तांको मामू मामू डाकुतिले हैला
Yes.
तो
ଡାକୁଥିଲେ ମା କହୁଛନ୍ତି ପୁଅ
ହଁ
କହୁଛି ତାଙ୍କୁ
ତାପରେ କଣ
ହାଣ୍ଡିଆ
ହାଣ୍ଡିଆ
ପିଇଲେ
ପିଆ ହେଇଛି
ଚିକେନ ଦେଲେ
ତେଣୁ ତାଙ୍କ ଭିତରେ କିଛି ପ୍ରିଭିୟସ୍ ହୋଷ୍ଟିଲିଟି
No.
ନଥିଲା ରାଦର ଯଦି ୱାଇଫ ର ଏଭିଡେନ୍ସ ଆମେ ଦେଖିବା ସେଇଟା କହୁଛନ୍ତି ଯେ ସେ କଣ ହେଲା ସେଦିନ ନା ଗୋଟେ ଆକ୍ୟୁଜ ଆସିଲା ହେଲା ଆସିକିନି କଣ କଲା ନା
Notice ଦେଖେଇଲା।
ସିଏ ଗୋଟେ ନୋଟିସ ନେଇକିନା ଆସିଥିଲା ଇଏ ନୁହେଁ ଯେ ନୋଟିସ ଆସିଛି ତା ପାଖକୁ ମାନେ ହାବିଲଦାର ପାଖକୁ ନୋଟିସ ଆସିଛି ତେଣୁ ମାଙ୍ଗରା ମୁଣ୍ଡା ଯିଏ ଆପ୍ଲାଣ୍ଟ ନମ୍ବର 1 ସିଏ ନୋଟିସ ନେଇକିନି ଆସିଛି କୋଇରା ପୋଲିସ ଥାନାରୁ ଏବଂ ତାକୁ ଆଣିକିନି ଡିସିଷ୍ଟ କୁ ଦେଲା ଡିସିଷ୍ଟ ତାକୁ କହିଲା ମାଙ୍ଗରା
ଦି ଜଣଙ୍କୁ ଧରିକି ଆ।
ଯାଇକିନି ତାଙ୍କୁ ଡାକିକିନି ଆଣେ ହେଲା କାରଣ ପୋଲିସ ତାଙ୍କୁ ଖୋଜୁଛି ହେଲା ଯଦିଓ ଭର୍ସନ ଅଫ ଦି ଆଇଓ ଇଜ ସମଥିଙ୍ଗ ଡିଫରେଣ୍ଟ ଆଇଓ ହେଲା ଆମର PW 13 PW 13 ଆଇଓର ଏଭିଡେନ୍ସ ହଉଛି ମୁଁ ଖାଲି ଜଣକୁ ଡକେଇଥିଲି
କେଟେ ମୁଣ୍ଡାକୁ
କେଟେ ମୁଣ୍ଡାକୁ ଡକେଇଥିଲି
ପାରା 4 ରେ
C PW 13 ପାରା
4
ଆଚ୍ଛା ତାପରେ କଣ ହେଲା ନା since a quarrel had taken place between the accused Mangara Munda on one side and the other accused persons on the other side. After a while, after taking tea, my husband left the village Uradihi to call the accused person. At about 3 p.m., my husband came to our house along with the accused persons and instructed me to serve them food. On being instructed, I served country rice, beer, and one plate of chicken to the accused persons. After taking their meal, the accused persons being accompanied by the so and so. तो तांको नारे जदि केस देइथिला से जो आरो दीटा नारे अपलान नंबर 1 देइथिला केस का नारे ना अपलान नंबर 2 और 3 नारे जदि आ एविडेंस को एतो सेति पई गोटे नोटिस आसिला से थाना बाबू ता कोन करचंती आकु करचंती जे तू जाईगिनी ताकू डाकिना कळी कोन करथिले
those थाना who has not treated them ମୁଁ ତାକୁ ଦେଲି
हां तेणु वर्तमान जदि तांकर से दीटा अक्यूज्ड करो कहा नारे ग्रीवांस थी ताले सी होची अपलान नंबर 1 अगेंस्ट सी नेगिनी रिपोर्ट कला सी नोटिस नेगिनी आस्तेला तो व्हाई दे विल जिए तांगु डाकिकिनी आनिकिनी तांगु घरे खाइबा को दउची एवं नोटिस कंप्लाई करूची सी ता अगेंस्ट तार कोन थिबो ता व्हाट इज द मोटिव सो द मोटिव पार्ट इज आल्सो लैकिंग इन दिस केस no clinching evidence अच्छा circumstantial evidence रे motive रो importance बहुत रही so direct evidence रे motive प्रमाण न करी पारले that is not of much relevance but when your case is based on circumstantial evidence that also you would bring that distance in the circumstantial evidence motive has its relevance so the prosecution is to prove the motive. So we want to see all this decision on day after tomorrow. Bring it, we'll deliver the judgment in court on that.
The petitioner received expired on 16th of this month. And extension of tomorrow day after. My lords, I am mentioning two criminal appeals of the year 2022, wherein I filed an IA seeking permission to prepare paper books, my lords. Will be taken up.
Not file paper. Yes. It cannot be hard as 2010.
And another my lord, tied up bail application. My lord, criminal appeal 1214/23. IA for bail.
Criminal appeal IA for bail.
Criminal appeal and bail.
Criminal appeal aye for bail, my lord. 8 years conviction. Yes.
May I please, Lord?
Okay.
Lord, I am on BC, my lord.
Yeah.
Last week, my lord, I have mentioned one BLAPL 8088 of 23, where the petitioner was in custody since 7.5 years.
Okay.
His mother was died in the last Sunday, my lord.
File an interim application. Send your associate here and give a
My
copy
lord,
to State Council so that he will obtain.
7.5 years before trial, my lord.
You said the mother has expired. So you move an application for interim bail. Give a copy so that instruction can be obtained.
My lord, I will file.
Next.
Supplemental list, item number 1.
May I please, Lord, on behalf of Vijay Kumar Parade, my lord, the appellant is convicted under section 307, 7 year, and 27 clause 1, 7 year.
But admit call for the trial court record. Interim applications for bail and sterilization of fine to be considered after receipt of the trial court record. Deposition copy to be supplied to the State Council. Yes.
Item 2.
Madam Pleasure, the appellant has been convicted under section 30 part 1, my lord, and sentenced to undergo RI for 10 years, my lord.
Same order.
But I am just now supplying the deposition
The
copy.
deposition copy supplied in court. Yes. Next.
My lord.
Item 3.
On behalf of Mr. Das, Lordship,
Yes.
appellant convicted under section 13(2) 13(1)(e) of the PC Act and sentenced to undergo RI for 2 years and pay a fine of rupees 50,000. Running page 78.
RI for 2 years.
2 years.
And you are on bail during trial.
Lordship. 84,000 DA. DA only 84,000.
84,000 ଟଙ୍କାରେ ଆପଣ DA କରୁଛନ୍ତି.
84,000.
It's most strange. You are wasting time. You are wasting time. 84,000 ଟଙ୍କା ଗୋଟେ ଲୋକ ଆପଣ
75
ଚେକ୍ ପିରିୟଡ
years.
କେତେ ବର୍ଷ?
period ହଉଛି 1986 ରୁ 92.
19 so ଗୋଟେ ଲୋକ 84,000 ଟଙ୍କା explanation ଦେଇ ପାରିଲେନି in between the so many periods. ତାର disproportionate asset କରି ତାକୁ case ଇଏ କରି is it not a wastage of time?
My lord, FRDA was 4 lakhs.
All right. Yes, admit bail granted, stay realization of fine.
My lord, since 9/2/2024, I have filed my appearance memo.
Simon Das and senior advocate submit that he has filed his appearance memo since long. Let the registry place the same on record. Yes.
And my lord, can I file this one also? That
you have already filed. You said
already filed.
Or another file. Take it. Yes. Name of Mr. Das be reflected in the cause list transfer. Yes.
Item 4.
Gmail. And last week, the matter was before your lordship for interim bail, and lordship has directed to get instruction mail.
May I pray, my lord? Can I next week, my lord?
On what ground you are seeking for interim bail?
Wife element, my lord.
Medical document has been annexed.
Yes, my lord. It is fine.
And counsel for the state submits that he has already sought for instruction. That is IN number 94 of 24 for interim bail on the ground of ailment of the wife of the appellant. And instruction is awaited. Put up this matter on 20th of February 2024. Yes.
Okay.
Item 7.
Yes.
The appellant has been accused to have committed offence under section 147, 148.
What happened to the notice, Mr. Madam?
Notice, my lord, could not be solved.
Why? So the matter is to be heard. There is no other way out. If he doesn't remain present in his house, what can be done?
My lord.
Yes, you have received the case diary, Mr. Das?
My lord, not received, my lord.
Not received.
And because it is tagged in another bail application they have mentioned, but it's not let me obtain test.
Okay. So it will come on 20th.
One thing they file an affidavit.
What is that affidavit?
Regarding the, my lord, also pass an order on that, my lord. In para 3 of the affidavit, they have mentioned that the appellant counsel, Sri Sushant Kumar Pradhan, has received copy of letter so and so dated 30th 10/2023 from the Deputy Superintendent Lajpur Central Jail, Surat, Gujarat, addressed to Gundicha Brindaban Parida. And the order of the so and so passed by the Honorable High Court of Gujarat in criminal miscase so and so by WhatsApp cell coil. Copy of the document annexed, my lord. And on that basis, my lord, also we have obtained an instruction. That is also there, my lord, a Hindi language, my lord. There they have mentioned that is the here, my lord, the accused is the Robbie alias Rabindra Parida, my lord. And there the name is the Rabindra alias Robbie Brindaban Parida. Whether the same person is not, they have not filed anything. So on that basis, they are telling that at the time of the date, well, he was inside the jail custody. They are taking the ground. And as per the whether the same is the Rabindra Barun Parida,
Father's name you check it.
That they have not mentioned it.
Which where?
Here, my lord. They have not taken any awardment. They have only written a filed an affidavit that such a letter has been received by them. Whether they have not clarified whether this Rabindra, the President Rabindra Parida is the same Rabindra.
No, are they taking any awardment in the petition
No.
that this Rabindra Parida, son of so and so, in such and such jail?
No, not also there.
Then why are you worried?
Yes,
I cannot entertain that ground. No, there is no averment here.
No, I've gone.
Leave it. Yes, any other contention?
Let us CDB, my lord.
Argue the matter.
And let me obtain CD, my lord.
Okay. Land Council for the state has produced the written instruction dated 12/2/2024 of IIC Kodla Police Station, which indicate that notice could not be served on the informant due to his absence at Hajia-Sahi Kodla. The written instruction is taken on record. The Land Council for the state seeks some time to produce the case diary, put up this matter, give a date. Yes.
Item 8. Item 16.
May I please, Your Lordship? The appellant has been convicted for a period of 12 years and fine of rupees 2 lakhs.
कौन
For
ला
the
period of
12 years and fine of rupees 2 lakhs for the commission of offence under section 20B2C of the NDPS Act. The appellant is in custody since 14/12/2013. The Lordship has granted interim bail for a period of 3 months.
total period ବର୍ତ୍ତମାନ କେତେ ହେଲାଣି
10 ବର୍ଷ
ଆଣିଛନ୍ତି କି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ
ନା।
ଆପଣ ଆଣିନାହାନ୍ତି
on being demand, the jail authority has denied to supply the copy. For that reason, a report may be called for.
କାହିଁକି ଦଉନାହାନ୍ତି ଆପଣ they have got a right to, that is the direction of this court that
ନାଇଁ ମ ସମ୍ବଲପୁରରେ
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ସେମାନେ ବେଲ୍ କେମିତି ମୁଭ୍ କରିବେ ତାଙ୍କୁ କୁହାଯାଇଛି ଯିଏ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମୁଭ୍ କରିବେ ତାଙ୍କୁ ଦେଇଦେବେ ବୋଲି ଲେଖନ୍ତୁ the learned counsel for the petitioner submitted that out of 12 years of sentence imposed by the learned trial court, the petitioner has already undergone more than 10 years of sentence. And when the petitioner asked for the custody certificate to the concerned jail superintendent, the same was not supplied to him. If this is the state of affair, correct state of affair, it is very unfortunate that the petitioner who is seeking for bail on the ground of his prolonged detention has been deprived of the custody certificate, which he has got a right to get from the concerned jail superintendent. Be that as it may, the learned counsel for the state shall obtain the custody certificate of the petitioner on the next date, and this copy of the order be brought to the notice of the concerned jail superintendent so that it is not repeated in future. Put up this matter on 22nd of February 2024. Free copy of the order be handed over to the land. Yes.
Item 17.
Please, my lord. My lord, here, out of my lord 10 years sentence that he has already undergone more than 8 years in custody. That is the custody certificate. Page, sir, 44. Imprisonment for 10 years and to pay the fine.
Okay, this is
8 years, 5 months.
10 years, fine of rupees 1 lakh, in default to undergo RI for 1 year. And offense is 20B2C. देखिए या नाला कालिया alias Somnath.
Somnath Sahani.
They are not the petitioner.
Petition number 3.
अपन कहाँ पे move कर देंगे? Appellant number 3.
3. Somnath Sahani.
Yes.
Total period, Mr. Tripathi?
Yes, ma'am. 8 years, 9 months.
8 years, 9. And this is dated, এটা কেবে কার date কেবে? 12/1/2024. All right. IA number 2405 of 2022. This is an application for bail of appellant number 3, Kalia alias Somnath Sahani. The learned counsel for the petitioner submitted that out of 10 years of substantive sentence imposed by the learned trial court, the petitioner has already undergone 8 years and 9 months of sentence, which should be evident from the custody certificate dated 12/1/2024, issued by the Superintendent District Jail Board, which is produced before this court and taken on record. He further submits that since there is no chance of early hearing of the appeal, even though paper book has been prepared, the bail application of the petitioner may be favorably considered. Learned counsel for the state oppose the prayer for bail. Considering the submission, sentence imposed by the learned trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, and keeping in view the ratio laid down by the Honorable Supreme Court in case of Muhammad Muslim, it is allowed. So, bail of A3 allowed. Yeah. Yes.
Item 18.
My lord, next matter, out of 10 years,
Which one? Which one?
next matter, 18, 1-8.
ନା ଆର ଆଉ ଗୋଟେ ଅଛି
ଆର ଗୋଟେ ଅଛି ପରା CRLA
544
Lordship, I have no instruction in this matter. CRLA 544 of 2016.
All these councils belong to your chamber.
Yes, your lordship.
So, okay, mention is made
the report was called forward
on the report.
19/12
Madhyambera has not surrendered before this court. NBW issued so and so its production. Okay. A submission is made on behalf of Mr. Saurachandra Mahapatra and senior advocate that he has no instruction in the matter. Therefore, the names of Mr. Mahapatra and his associates shall not be reflected in the cause list henceforth. Period the report of the London Trial Court dated 2/1/2024, from which it appears that the appellant, after availing the interim bail period, has not surrendered, for which a non-bailable warrant of arrest has been issued against him. The London Trial Court said on the arrest of the appellant, the London Trial Court shall immediately intimate the said fact to this court with further instruction as to whether the appellant wants to engage his own counsel or a counsel from the legal aid is to be provided to him for this appeal. Copy of the order be communicated to the London Trial Court. Yes.
Congratulations.
Yes.
My lord, out of 10 years substantive sentences, he has already undergone 8 years, 4 months in custody.
Yes.
Sir,
18.
out of
Milord,
10
in
years,
this case, there was a noting that he has filed the Vakalatnama without the attestation.
that is wrong. So what happened when he was in interim bail? He has also filed the Vakalatnama during the interim bail period.
That flag no written note of submission only not yet filed. Niranjan Pandya associates filed for the appellant taking consent of the previous counsel but without attestation from the jail authority. So during this period,
Interim bail, when he was also granted interim bail, he has filed the Vakalatnama.
Where is that Vinama? That you have filed on 27/3/2023.
Sir.
So
During that time, he was on interim bail and obtained the consent from the previous counsel and given that acknowledgement.
all right. The Mr. Pandal and counsel appearing for the appellant submits that while the appellant was on interim bail as per the order dated 28/11/2022, passed in IN number 410 of 2022. During that period, he has signed the Vinama, which is filed before this court after obtaining consent from the previous counsel. The Vinama filed by Mr. Panda and his associates is accepted. Yes, what is your submission?
My lord, out of 10 years, he has already spent 8 years, 6 months. Because he is languishing in jail custody since 11/10/2015.
It is 10 years, 1,20,000.
Yes.
So, where is the custody certificate?
Yes.
Custody certificate direct.
7 years, 10 months, 6 days.
7 years,
10 months, 6 days.
What is the date?
Date होती 8/1/24.
8/1/24.
हाँ.
Who jail law?
ଏଇଟା ହେଉଛି ବୌଦ୍ଧ.
Both.
Yes.
The copy would diuntu record purpose ପାଇଁ ଲେଖନ୍ତୁ IN number so and so. This is an application for bail. Considering the submission made by the learned counsel for the petitioner that the out of 10 years of substantive sentence, the petitioner has already undergone 7 years and 10 months of sentence as on 8/1/2024. And even the paper book has been prepared, there is no chance of early hearing of the appeal in the near future. And after going through the custody certificate produced by the learned counsel for the state and keeping in view the ratio let down in the case of Muhammad Muslim, bail is allowed.
All right.
Item 19.
Here, my lord, appel and petitioner convicted is sentenced to undergo 10 years and
କୋଉ ଜେଲ୍ ଏଇଟା? ବାଲେଶ୍ୱର।
Item 24.
May I please? Here in this case, my lord, petitioner is custody more than half.
So how many appellants are there? How many appellants are there in this case?
Yes, lord.
Huh? Appellant କେତେ ଜଣ ଅଛନ୍ତି?
I am my lord on behalf of Pukhraj Goda.
ଏ appeal ରେ କେତେ ଜଣ appellant ଅଛନ୍ତି? appeal memo ଅଛି ନା ନାହିଁ?
This is transfer bill, man.
फिर appeal memo ନାହିଁ ଆପଣ argument କେମିତି କରୁଛନ୍ତି?
My lord, 5 numbers of appellant in this case.
ଇଏ ଆପଣ ଫାଇଲ କରୁଛନ୍ତି 5 ଜଣଙ୍କର?
No, I am filing on behalf of the Pukhraj Goda. Appellant number 1.
Where is your appeal memo?
Oh, appeal memo.
You have filed 2 bail applications, interim applications for bail, 1 interim application for interim bail.
Yes, lord.
Why 2 bail application and 1 interim application? You have filed 1 interim application for bail in 21.
Yes,
Again, you file another interim application
for bail.
for bail
Because-
in 23.
Yes, lord. Because
Another is there for interim bail. माने जहाँ
Because-
file करियो अपन.
why I am filing main bail application because petitioner is in custody 9/7/2018.
अच्छा आगटा कौन हबो जोटा पेंडिंग अछि सेटा कौन हबो? ସବୁ 2 ମାସକୁ ଥର ଲେଖା ଗୋଟେ ଗୋଟେ ଫାଇଲ କରିବେ ନା କଣ?
Actually total bail ଯାଇନି ସେଟା ତାଙ୍କ ଫାଦରଙ୍କର
ମୁଁ
illness
ପ୍ରଶ୍ନଟା କଣ କରୁଛି ବୁଝିଲେ ନା ନାହିଁ?
yes lord
ଗୋଟେ ବେଲ୍ ଆପ୍ଲିକେସନ ଯେତେବେଳେ ପେଣ୍ଡିଂ ଥାଏ ଆଉ ଗୋଟେ ବେଲ୍ ଆପ୍ଲିକେସନ ଯଦି ସେଟା ଇଣ୍ଟରିମ୍ ବେଲ୍ ନୁହେଁ ମେରିଟ ରେ ପୁଣି ଆଉ ଗୋଟେ ଫାଇଲ କରିପାରିବେ କି?
ସେଗୁଡା ନଟ୍ ପ୍ରେସ୍ କରିଦଉ।
not fresh for the main bail application.
IA number 654 of 2021, the Land and Council for the appellant does not want to place this application, disposed of as not placed. Now, second is that interim bail कौन ପାଇଁ file करथिले? Whether you are pressing that or on you want to move bail on merit.
Yes lord he was in custody 9/7/2018 more than
ମୁଁ
5
କଣ
years custody.
ପଚାରୁଛି ଟିକେ ବୁଝନ୍ତୁ।
ଇଣ୍ଟରିମ୍ ବେଲ୍ ଟା କରିବ ନା ମେରିଟ୍ ରେ?
interim bail ପାଇଁ କୌଣସି
No,
ତାର ଦେହ
merit
ଖରାପ କିଛି
merit
merit ରେ କରିବ।
yes lord
So interim bail not pressed.
yes lord
Alright. Now, what is the conviction and what is the sentence imposed?
my lord it is conviction my lord 10 years man.
Conviction 10 years, no conviction under section so and so, sentence is 10 years.
Conviction under section 20B2C of NDPS Act
Yes,
and sentence my lord 10 years.
and fine is 1 lakh.
Yes lord
You are okay. So how many years you are in custody?
my lord custody since 9/7/2018.
Have you got the custody certificate?
No my lord.
Mr.
No,
Tripathi,
that has not called.
get it.
Yes.
Land and Council for the petitioner submits, that is IA number 80 of 2024. Is an application for bail. Land and Council for the petitioner submits that out of 10 years of sentence imposed by the Land and Trial Court, the petitioner has remained in custody since the petitioner has remained in custody 9/7/2018. 19/7 अच्छा
Well, on the last occasion, we have already filed the document of the bailor.
हाँ
Bailor document already we have filed.
लोग को बाहर लोग को की
Yes, it is.
ରାଜସ୍ଥାନ।
राजस्थान लोग आगे कस्टडी सर्टिफिकेट हम आगे देखे कौन so 19/7/2018 therefore he has already undergone half of the substantive sentence. Now So, Mr. Tripathi,
Yes.
when the matter was taken off, previously you a last order ta dekhilo, is it 10/5/23? Tapre aw asini. So there was a direction to the London State Council because this man is from Rajasthan to obtain instruction about the address verification.
The address was verified in term of the IA.
हाँ
IA. IA जोटा file करता तो
पहला जी address verification है
He
ये
is.
found to be correct.
Yes.
All right, look on. The London Council for the State, as per the order dated 10/5/2023, has obtained instruction to the effect that the address furnished by the appellant in the cause title is a correct one. Now, there was a direction that you are to produce the names, address, and documents of two local securities. Did you furnish it?
No, Miller. That is not received by me.
Siada only le kon
I'll take up next week.
siya
I will provide.
ଦେଇଛନ୍ତି ନା ନାହିଁ ଦେଇନାହାନ୍ତି
As per my instruction, we have already filed. We have already provided.
But we have not received.
give another. The London Council, let the London Council for the petitioner furnish the names, address, and documents of two local sureties to the London Council for the state, on receipt of which instructions shall be obtained from the concerned police station regarding the genuineness of the bailers and authenticity of the document furnished. Put of this matter, we commencing from 26th February 2024. Supplying by day after tomorrow.
Yes, sir.
Item 26.
Your Lordship, I am appearing on behalf of GM Rath. In the last occasion, interim bail was granted, and as per the instruction I have received, the petitioner was released on 18/11/23, 2023. The 90 days gets over by 17th February.
All right. The London Council for the appellant submits that the interim bail period has not yet expired, and the matter may be taken up in the first week of March 2024. We'll file the surrender certificate. Put up this matter in the week commencing from 4th March 2024. Yes.
Item 27.
My pleasure, Lashmi.
Item 30.
May I please? And conviction under section 20B2C NDPS Act, my lord. Sentence may arrive for 10 years, my lord. Fine 1 lakh, my lord. My lord, grant the interim bill 31/2023, my lord. Period of 3 months. Petitioner already surrendered at the right time, my lord. The surrender certificate already produced, my lord. 7 years above in custody.
at flag B. ବର୍ତ୍ତମାନ କେତେ ହେଲା ଟୋଟାଲ ପିରିୟଡ କେତେ
7 year 8
କାଇଁ?
6 year 8 months.
ଡକୁମେଣ୍ଟ ଦିଅନ୍ତୁ
ଦଉନାହାନ୍ତି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ
ଆଣନ୍ତୁ ଡକୁମେଣ୍ଟ କେତେ ଆପଣଙ୍କ ହିସାବରେ କେତେ ହଉଛି
6 year 8 months.
the 10-year sentence
10 years.
Land Council for the petitioner submits that out of 10 years of substantive sentence imposed by the Land and Trial Court, the petitioner has already undergone 6 years 8 months of
8
sentence.
months.
Since no custody certificate has been produced, let the Land and Council for the state produce the same. Put up this matter in the week commencing from 26th February 2024.
Item 31.
May I, Lordship, please?
32.
Item 32.
May I please, Your Lordship?
My lord, in 31, my lord, pardon. In 31, my lord, in sub-item 628 of 2020, 23, my lord, in sub-item 4, my lord.
Item 31.
Yes, my lord.
31 ରହିଲା ପରେ 26 2 କୁ
But I filed an interim application, bail application.
Which
That
one?
is not in list, my lord.
1244. କୋଉଥିରେ
He
file
is
କରିଛନ୍ତି?
saying, my lord,
628, 628
628 ରେ
2020.
ଗୋଟେ interim application file କରିଛନ୍ତି.
Yes, my lord.
What is that IN number?
231 of 2024. my lord.
31 of 24.
Yes, my lord.
On what ground you have filed?
Mother is not well, my
Mother
lord.
self filed.
Hmm.
Have you received the copy of that 231?
Already filed.
yes, my lord. I have received
All
it.
right. এটা লিখিবে এই অর্ডারটা লিখিবে CRLA number 628 of 2023 Rakesh Kumar Baroda. Learned and counsel for the appellant submits that an interim application by IN number 231 of 2024 has been filed for interim bail on the ground of mother settlement. है ना? Learned and counsel for the state has received the copy of the interim application and seeks some time to obtain instructions. Put up this matter on 26/2/2024.
Okay,
Yes.
my lord.
May I please, Your Lordship?
Yes, Mr. Samantrai, what is the CRLA for?
My lord, I have filed against the order of charge, my lord. But I am on IN number 2859 for limitation, my lord. And here, my lord, limitation for 32 days has been pointed out by the registry, my lord. Initially, the petitioner filed a revision petitioner before your lordship, my lord. Later on, amendment petition was filed because the charge has been framed meanwhile. Thereafter, the lordship has directed to withdraw and file a better application. That's why the petitioner filed the CRLA, my lord.
No, you are challenging, as it appears from the prayer portion, you are challenging the order dated 2/3/2023.
My lord, my lord.
So
2/3/2023. 2/3, my lord. Yes, my lord.
23 and 2/3/23 order indicates if you come to the operative portion of that order, it indicates in page number 4, running page 51, internal page 4, that the case was posted for examination of charge sheet witnesses on 28/3/2023 and 29/3/2023. So that means the recording of evidence of witnesses has already commenced or what?
Yes, my lord.
Witnesses have been examined. କେତେଟା ସାକ୍ଷୀ ହେଲେଣି?
My lord, some of the witnesses has been examined, my lord.
Then
I have not the exact figure of how many witnesses has been examined, my lord. But
So
some of the witnesses has been examined, and without any original document, my lord, trial is going on, my lord. Without a single document, my lord. And so far the present petitioner's case is concerned, my lord. The earlier,
at
my
this
lord.
stage, why is the question of challenging the when the evidence has already started, you have started cross-examining the witnesses. So matter is and for 1 year almost the trial has proceeded. So at this stage, why I will interfere with that?
My lord,
And if you got a good case, then you will be acquitted ultimately after. And if they have not filed the original documents, then you raised objection at the time of marking, and it will be marked with objection. And what would be the ultimately evidentiary value that is to be taken into account at the time of final judgment? And you will argue the matter that they have not produced the original documents. So
my lord,
this Xerox copy or whatever it may be inadmissible.
my lord, kindly
How
have
many
a glance
witnesses have
on
been examined?
page 38, running page 35, annexure 5, your lordship.
I'll not go because the already witnesses have commenced the examination of the witnesses. Lekhandu, are the learned counsel for the appellant delay condone kar diyantu, है ना? This the learned staff report has pointed out that there is delay of 132 days in filing this CRLO. Mr. J.P. Patra, learned special counsel appearing for the state of Odisha in OPID Act matter is present. After hearing the learned counsel for both the parties and taking into account the grounds taken in the interim application, I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Tapare main application lekhantu. This criminal appeal has been filed under Section 13 of the OPID Act, challenging the order dated 2/3/2023 passed by the London presiding officer designated court under the OPID Act Balasore in city case number 3C of 2019 in framing charge under section 420, 467, 468, 471, 406, 120B of the Indian Penal Code, sections 4, 5, 6 of Price Cheats and Money Circulation Schemes Banning Act 1978 and section 6 of OPID Act. The impugned order reveals that the case was posted for recording the evidence of the witnesses on 28/3/2023 and 29/3/2023, and summons were issued to the charge sheet witnesses. When a query is made to the London counsel for the appellant regarding status of the case, he fairly submitted that some of the witnesses have already been examined. In view of such statements, since trial has already progressed and the petitioner appellant is participating in the trial, at this stage I am not inclined to interfere with the impugned order. The London counsel for the appellant, however, submitted that without the original documents, the London trial court is proceeding with the trial, and documents which are produced before the London trial court are inadmissible. Those points
One
can
more.
be very well taken at the stage of final argument, and the London trial court is to consider the same in accordance with law.
I
Accordingly,
may be
yes.
one more submission may be recorded, my lord. As per the annexure 5, my lord, the Calcutta High Court, my lord, already stayed the company's affairs, my lord. In 2017, your lordship.
Let us
Lordship,
forget it. Yes, yes. Next, accordingly the CRLA is disposed of. Yes, next.
Same cannot be trial together, my lord.
Item 33.
May I please, your lordship? Yes.
Item 40.
May please your lordship, my lord. This is appeal against conviction, my lord.
Hmm.
Relevant person is page 33, my lord. Convicted under section 372 of IPC, my lord.
370.
Class 2.
Seven years.
Yes, my lord.
So, what is the allegation against you?
Against allegation, my lord, I took 3 persons to work in Maharashtra, my lord. Out of which the victim is not returned to the home, my lord. Other returned, but this victim didn't return. Therefore, case against lodged against me, my lord. Against under section 364. Thereafter, charges submitted under section 365, 370, 70 and 34 IBC. Convicted under section 370 clause 2, my lord. That person is aged about 35 years, my lord. That person who went with me, my lord, is about 31 years. And after staying there for 8 days, I came back, my lord. Thereafter 8 days, the other victims came, but this petition victim didn't come, my lord.
Victim is a boy or girl?
Boy.
Other two victims are 2 and 3. They're written.
It's 9.
So, what that particular victim has stated, he is examined as
Victim is
PW2
that
and
victim is not rescued, my lord.
That victim is not rescued. PW1 is the informant, father of that victim.
no, the ladies who accompanied that, the persons who accompanied that victim.
2, 3.
Two and
PW2 and 3.
3.
What they have stated. Because the section requires that
Exploitation, my lord.
Expression 370A.
trafficking of a person, then for the purpose of exploitation, and there must be also material that either using threat, using force, or any other coercion, by abduction, by practicing fraud, or by abuse of all these things are to be there.
Yes, ma'am.
If somebody voluntarily accompanies and he is aged about, as you said, it is more than 20 years.
31.
31 years is a man. So, and the best, the other witnesses, the 2 witnesses who accompanied that victim who has not yet come back, have they stated anything that this?
No.
PW2 evidence देखिए.
My lord, page 59.
Accused told me, as well as the victim, that he will provide a job in railway department in Maharashtra, and towards job he will pay salary of rupees so and so, with facility to take food in the mess. Thereafter, the victim so and so came to me, called me to accompany them. Finally, myself, so and so,
Robbie, Sandy, and the accused.
IA number 3017 of 23. There is an application for bail. The London Council for the appellant submits that The appellant was on bail during trial and he has never misutilized his liberty. And the victim is a man of more than 30 years. And he accompanied the evidence on record indicates that he accompanied the petitioner. So also PW 2 and 3 to get a job in Maharashtra. While PW 2 and 3 returned back, the victim stayed back and there is no material to attract the ingredients of the offense under section 370 bracketed 2 of the Indian Penal Code. সেটা দেখতে পারো judgment. Conviction is the 370 bracketed 2 though?
Yes, ma'am.
Of the Indian Penal Code. And there is also no chance of early hearing of the appeal in the near future, and therefore the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail, place the evidence of PW 1, 2, and 3. Considering the submission, nature of evidence adduced, fact that the petitioner was on bail, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay relation of fine.
Deep obliged.
Item number 41.
That's it. Kindly taken up next.
Okay. I'll wait for vigilance also. Yes, next.
Item number 42.
42 may please, my lords.
Yes.
My lord, convicted under 21C and 29 of NDPS Act, my lord. And the operating portion, my lord, 254 running page of my brief. Starts from. Sentence for 10 years of rigorous imprisonment, and my lord, 1 lakh, my lord.
Fine is 1 lakh.
1 lakh, my lord.
In default.
Default, my lord, 2 years of imprisonment.
So what sentence you have already undergone?
My lord, I'm in the custody since, my lord, 8/11/2020. And my lord, during trial, my lord, I was released on interim bail. That was on 18/11/2022. And my lord, I have surrendered on right time, my lord, that is on 17/2/2023. My lord, the entire case is on the basis of
supplied deposition.
Yes, my lord, that is on record, my lord. My lord, the entire case is on the basis of, my lord, official witnesses, my lord.
So,
my lord, and if my lord permits me, and the contraband was seized from other co-accused, that is Mir Rahat Ali, that is Munna, my lord. If my lord permits me, please, my lord.
The Mir Rahat Ali is his father. They
Mir
both
Rahat
came
Ali.
in the one motorcycle.
Black Pulsar motorcycle.
Yes, and
Black
it was
Pulsar
seized from the
motorcycle.
father.
Exclusive
And his
possession from
commercial
the right
quantity,
pocket, my lord.
90 grams brown sugar. And therefore, he's been convicted, and that Mir Rahat was still absconded.
What about that criminal antecedent?
My lord, no
So
criminal
for this present
antecedent.
petitioner, I have to take instruction.
My lord, that is also on record, my lord.
No. Current you move. Remain half of the sentence. We'll see
Yes.
the put of this matter.
My lord,
Also, the learned counsel for the state shall obtain the instruction about the CA.
my lord, criminal antecedent is also reflected. I have
Yes,
annexed that.
next.
Yes, my lord.
43.
Yes, Ms. Tripathi.
My lord, I am in virtual mode. My lord, 20 years RI, my lord, for the offense under section 376(2) and 376(3), along with the section 6 of the POCSO Act, my lord. And last occasion, my lord, issued notice to the informant.
Yes,
so
notice
the-
Notice could not serve me. I am giving.
Why? He was
Means
not there.
They are not available in that place.
Learned counsel for the state has produced the written instruction received from IIC Dharkot Police Station dated 13/2/2024, which indicates that the present whereabouts of the informant not be ascertained. The report is taken on record. Yes, he has supplied the deposition copy to
No,
you.
my lord.
Ms. Tripathi, you have not supplied the deposition copy?
My lord, let us come next week, my lord. I will serve. Tomorrow, my lord. Day after tomorrow, I will solve the
Right. Ms. Tripathi seeks for an adjournment and further submit that he will supply the deposition copies of the witnesses to the Land Council for the state during course of this week. Put up this matter on such and such day. Yes.
next week, my lord. Okay.
Item number 44.
Yes, Mr. Das.
May I please?
Respond.